Please be seated. Just wait for the photographer to finish. Okay. Good morning, ladies and gentlemen. On the 3rd of July 2020, the court suspended the court hearing in the Pulatov, Girkin, Dubinsky and Karchenko cases until today, the 31st of August 2020. The same members of the court are here today, and we hereby resume the court hearing in these 4 cases. The court notes that many of the relatives are with us today. They're upstairs in the public gallery. There are also foreign representatives with us, not physically in the room, from Canada and Ukraine. In addition, I note that the entire team of Counsel for the Relatives is present. You can see Mrs. Wageman, Ms. Skynes, and Ms. Collignon, Ms. Petter, Mr. DeLang, Mr. Langstraat, Mr. Peinenberg, and Mr. Wiedemann. In addition, Ms. Tunduskata and Mr. Van Eyck are present. They are counsel for Mr. Pulatov. In addition, the public prosecutors and members of the press are also present. A warm welcome to you all once again. For the record, I note that the case concerns the following suspects. Mr. Pulatov has not appeared. I therefore ask his counsel who are present whether they have been explicitly authorized to act on his behalf. Reply, yes. Okay, we can therefore continue the case against Mr. Pulatov. In addition, the defences are Mr. Girkin, Mr. Dubinsky and Mr. Karchenko. They have not appeared. That was also the case in the previous sessions. The court has already established that they were summoned to the hearings in accordance with the law. The court has therefore decided to try them in absentia, and the absentia trial has begun. The summons, which the court has already noted was legally valid, concerned not only the first session on the 9th of March this year, but also the summons for the first session days of a number of sitting blocks that have been timetabled, including the block of hearings which is being launched today, 31st of August. That means that the cases against these 3 suspects is continued today in absentia. Now, what we're dealing with is an unjoined but simultaneous treatment of the cases against these 4 suspects. That means that everything which is said today is deemed to apply to all 4 cases unless explicitly noted otherwise, or unless it is clear that it is only relevant to one particular case. For example, anything said by the defense of Mr. Pulatov. Now, a couple of practicalities. In other rooms within this room, in the press centre, the hearing can be followed on screen. I would ask everyone, please, to bear in mind the restrictions as a result of the coronavirus. Please keep your distance and obey the guidance of the ushers and the police. The hearing, once again, can be followed in Dutch and English on live stream, and the live stream will always show a picture from one of the cameras in the room. Which picture it is decided by the court technician in accordance with the press guidelines. For privacy reasons, recording of sound or images is not permitted during the hearing, and that applies also to the images being displayed on the screen in other rooms and in the press centre. Every time the hearing is adjourned, we will be told what time we will resume, and as soon as the hearing is interrupted, the live stream is stopped, and the images shown in the other rooms and the press centre will be stopped as soon as everyone has left the room.
This brings me to the agenda for today. After this introduction, the Public Prosecution Service, if it sees reason to do so, may take the floor on the state of play in the ongoing investigation. After that, the defence will be given the floor in order to proceed to an explanation. Subsequently, counsel for the relatives will be given the opportunity to take the floor. And counsel will address the questions raised by the court on the 23rd of March 2020. And counsel has commissioned an expert legal opinion for some of these questions, and this expert opinion has been provided to the court beforehand, as well as to the Public Prosecution Service and the defence. The defence and Public Prosecution Service can then respond. After that, the court, if necessary, will take decisions. Whenever necessary, we will be interrupting today's hearing for a brief break or a lunch break. Allow me to comment on the previous hearing days. When we started the previous block of hearings on 8 June 2020, counsel for the defence gave a presentation on the state of play with respect to their preparation. After that, public prosecution gave a presentation on the preparatory investigation, and applications were made for further investigation. Defence subsequently formulated its request for investigation insofar as it was capable of doing so, and furthermore, counsel for the relatives also made a number of requests. By court order of the 3rd of July 2020, the court granted, denied or suspended requests. The court also gave some instructions to the Public Prosecution Service, and the case was also referred to the investigating magistrate in order for the investigating magistrate to conduct further investigation. Now, what has transpired since the last hearing? The court recorded the previous hearing period in an official report, and this official report with its annexes has been included and incorporated in the case file, and a copy thereof has been provided to the Public Prosecution Service, the defence and counsel for the relatives. Regarding the progress of the follow-up investigation on the part of the investigating magistrate, the court has received information from the investigating magistrate. The investigating magistrate has started his investigation, and in order to properly carry out this investigation, the investigating magistrate on the 25th of August 2020 organised an organisational meeting and made arrangements with the defence and the public prosecution. The court received a report thereof. Mr. Poulato's defence has informed the court that it would like to give a brief explanation of the state of play of the preparation of its defence. Furthermore, they have informed the court that they shall not ask any questions with respect to the recommendation of the counsel for the relatives regarding the expert opinion, and they will not respond to the explanations and presentations made by the counsel for the relatives. They will defer to the court's decision in this respect, which means that the defence agrees with decisions of the court to be taken in this respect. By way of a letter of 10 July 2020 to the defence of Mr. Poulato, the public prosecutor elaborated on the requests of the defence to take cognizance of documents that have not been incorporated in the case file. And the public prosecutor also elaborated on the implementation of a number of instructions given by the court to the Public Prosecution Service. Public Prosecution Service, by letter of 27 August 2020, informed the court on what was done after this hearing of the 3rd of July 2020. In summary, the public prosecution has informed the court of the following. They have checked with the Netherlands Aerospace Centre and the Royal Military Academy into the availability of reports of Almas Ante. The Dutch Aerospace Centre has received these documents.
The Dutch Safety Board has informed them that this document cannot be provided to the Public Prosecution Service since these documents could not be disclosed as such. This also applies for two other documents that the Public Prosecution Service has required from the Dutch Safety Board. The Royal Military Academy informed us they do not have reports by Almas Ante. And it means that these documents will now have to be requested by the investigating judge. The Public Prosecution Service, furthermore, has allowed inspection to the defense team and the investigating magistrate of some documents and other documents that have not been added to the file. These are documents of the Russian Federation. Those that were received from the Russian Federation have been added to the file with regards to the position of the Russian Federation in the ECHR procedure and some media publications. Furthermore, the Public Prosecution Service requested with the Dutch Safety Board into names and capacity of persons that investigated the sound waves on the cockpit voice recorder. Those names have furthermore not been provided to the Public Prosecution Service because it is not allowed by law as such. The Public Prosecution Service has further contacted the defense team to visit the reconstruction of the MH17 aircraft, and that visit has not been executed yet. Furthermore, the Public Prosecution Service has also given more elaboration on the option to access files in the media file. Furthermore, the Public Prosecution decided on requests for infections. In short, it is what they've stated in the letter as to what they have performed after the hearing. There's also an addition to be expected to the file in the second week of September 2020, and the documents that the relevant documents are stated in the letter by the Public Prosecution Service. And in that framework, the court would like to the public prosecution to pay attention to the following. When discussing the completeness of the file with regard to combatant immunity, the Public Prosecution Service has mainly or actually exclusively addressed the criteria that are derived from Article 43 of the Additional Protocol 1. There was a lot of discussion in literature about the question whether combatant immunity can still be invoked by persons that belong to a group that is subject to the definition of a prisoner of war in Article 4 of the Third Geneva Convention. These criteria are similar, but the accents are a bit different and therefore may be relevant. The following criteria are mentioned. It is an international armed conflict. They belong to a party to that conflict. They are under command of someone with authority for subordinates. They have fixed and distinctive insignia. They bear arms openly, and they behave in accordance with laws and practices of war. The court now wonders whether the Public Prosecution Service would also like to express on the completeness of the file in case the court would find that it should also be tested against the criteria that can be derived from the definition of prisoner of war in the Third Geneva Convention. I would now like to address the further planning and hearing blocks. In the next few weeks, we've planned hearing days as of today, as of the 28th of September 2020, and as of the 2nd of November 2020. With regards to the year 2021, we have planned various hearing blocks as of the 1st of January 2021, as of the 15th of April 2021, as of the 7th of June, as of the 6th of September, and as of the 1st November 2021. On the 3rd of July, the court has already mentioned these hearing blocks. Afterwards, there were some changes in the planning, and the exact dates for each period are available on the site of this case, courtmh17.com. And I would like to add that as applies to days, we've planned weeks, but it doesn't mean that all days of these weeks will be used, because this is closely linked to the progress at the hearing. Now, the agenda for the present hearing block that starts today. In the decision of the Court of the 3rd of July, the Court has determined that as of today, the position of the relatives would be discussed. The Court has phrased any questions, which was on 23rd of March 2020, with regards to the position of relatives. These queries were about the jurisdiction of the Court, to decide on any claims for compensation by relatives, any granting of leave to proceed in default of appearance for civil claims, the question what type of civil law applies, how we should find that type of law, and the question whether other bodies have already paid damages to the relatives. Answering these questions is not just important to be able to assess any claims for compensation by relatives. If this case would lead to decisions in which claims for compensation would be allowed, then these decisions will be assessed. If they are to be implemented abroad, they will have to be assessed by foreign judges that will have to decide whether the court had jurisdiction based on internationally accepted grounds. It cannot be excluded that any claims that were awarded will also be relevant in procedures at international courts. Now, the court has received an expert's opinion by the Relatives Council, and it was comprised on their request. Now, this expert opinion addresses 3 of the questions asked by the court, which is the question into jurisdiction of the court, leave to proceed with civil claims in absentia, and what civil law applies. The Council for the Relatives will explain this expert's opinion today, and besides some claims of injured parties, it will also address what their opinion is about exercising the right to address the court, the number of relatives that considers to address the court, and in what type they will do so. Before the Council for the Relatives will have the opportunity to speak, the public prosecution and the defense team of Mr. Pulatov will have the opportunity to speak about the current status of affairs in the investigation and the addition to the file and the status of the preparation of the defense. I'm just looking at the public prosecution service. From the correspondence that we've seen last week, I read that you have indicated, well, that it is normal to first address what happened, and that I have not done so very elaborately, but I've just mentioned several items. I would like to ask you, do you feel the need to add to that today? No, thank you. Your summary was exactly as I would have done so myself, so I would repeat you. Okay, thank you. Now, I would like to address the defense. You've stated that you indeed want to clarify the present status. Please go ahead. And for all of you who speak today, your microphone operates best if you aim it at yourself, as I do. Thank you, Your Honor, public prosecutors, and all of you present and counsel for the relatives. I will summarize what we've done in the past period. We have made a number of requests to the Public Prosecution Service. First of all, we have requested, or actually, if we look at it from a time perspective, in the end, we've asked for further information that relates to the procedure that the Dutch state has brought before the ECHR against the Russian Federation. In particular, it is with regard to there was alignment with the Public Prosecution Service and whether they shared information. Furthermore, we've asked for information about another matter. There was an article published in the AD newspaper with regard to Vadim Lukashevich, which would state that he would have visited the Netherlands on invitation of the GIT, but and that he would have been interviewed with regard to MH17, but he could not make any statement about that. We have asked the Public Prosecution Service for more information, and furthermore we've asked the Public Prosecution Service to provide a number of documents or to add these to the file. And in addition, and we've discussed this before, we would like to discuss the matter with our client in a meeting. We tried to travel to the Russian Federation. Of course, corona measures are still an impediment to that. It seemed like we could do so last week. We had already taken our COVID tests and they were negative, but the flights were cancelled. We tried to travel through other European cities, but flights that are offered at one time are withdrawn an hour later. You can't find them on the internet anymore. We didn't succeed. We managed to book a flight very recently, and we did so if it will continue. And when we traveled here this morning, it looked a bit different than in the past few months, because there are some planes now when we look at the sky. So if the flight would still take place, we will travel to Russia on the short term. We hope that will be successful. We will not mention the exact date, you will understand, and that is because of the information about council that were under surveillance in other cases. Now, what we did furthermore is we suggested, and that is due to the fact that we don't want to spend time that's unnecessary, we would like to submit or suggest that we will submit our requests for investigation in writing and receive a response in writing. That doesn't apply to all of the requests that we have. Also during the hearing blocks, we will do so and present our requests. But if we have anything ready, we may not have to wait until there's a new hearing. We can submit these requests in writing and receive responses to that. And as seems to be obvious, it could also be summarized at the public hearing. And we've made a suggestion to find a practical way to deal with this. Furthermore, on the 25th of August 2020, as you stated, Your Honour, there was a pre-trial meeting at the investigating judge. We talked about the statements of witnesses X48 and M58. We've requested for Russian translations and we've understood that we will obtain these. We talked about the difficulties we have in visiting Gilserijen with an appropriate expert. It is so difficult to find somebody that has all the right qualifications but has not been engaged yet by the Public Prosecution Service. So now we've decided that we will visit the reconstruction ourselves without an expert to see if we would like to visit once again with an expert, but to simply see what is available there. We will arrange that with the Public Prosecution Service in the next few weeks. We talked at the investigation judge about the request for legal assistance made by the investigating judge following our requests, on which your court has decided that specific documents must be provided. These are the requests for legal assistance, and I quote, that were made to the authorities of the Russian Federation, interim decision under 2, 3, F and 5, to the United States, interim decision under 4, and to the Ukraine, the interim decision under 3 D, end of quote. The investigating judge told us that now we will not be allowed to inspect these requests for legal assistance, but that the documents that are relevant can be inspected by the defense team after the requests have been executed. We repeat our request to be able to inspect these requests, and we request you to order the investigating judge to provide us with a copy of these requests for legal assistance. Now, I will explain to you why I've asked that. If we wait until these requests have been executed, up until that time we cannot assess what the phrasing was of these requests for mutual legal assistance, and we cannot assess whether we feel that the order of your court has been complied with. And therefore, we reserve the right to be able to, after we've had insight, to add to these requests for legal assistance. Now, there could be a reason to do so if we feel that request should have been phrased in a different manner, or that there is a reason, following the first response to that request for legal assistance, that we need to ask additional questions. And therefore, from a practical point of view, it would be efficient to have insight in these requests for mutual legal assistance as soon as possible. Now, at the investigating judge, we discussed some other documents, and these are documents that have not been added to the file. These have not been added to the file based on 149D of the Code of Criminal Procedure. We have stated that we feel that some relevant documents that have not been added to the file must be added to the file. And the following applies in that respect. And I will briefly explain the framework with regard to the Article 149B of the Dutch Code of Criminal Procedure. Based on Section 149A, first paragraph, the public prosecutor has the responsibility to compile the court docs. Now, the court documents are all the documents that can be important for the decision to be taken at the hearing, except for the stipulations of Section 149B. So all documents that are relevant to the court to answer the questions of Section 348, 350 of the Code of Criminal Procedure are court documents and must be in the court file. Now, an exception to that rule can be found in 149B, which provides an opportunity to withhold documents from the file that are relevant if there are compelling interests. And these are the interests stated in Section 187D. And when these interests are at stake, then they can be withheld. In the present case, the public prosecution has holds that said situation occurred several times, and therefore they've obtained a written authorization of the investigating judge and have not added these documents to the file. The ECHR allows such limitation due to internal disclosure under conditions. Now, case law of the ECHR states that the prosecution authorities disclose to the defense all material in their possession for or against the accused. But limitations to this are possible if it's strictly necessary and when these are compensated for. Now, the legislator finds this, as is demonstrated by drafting history, in the procedure of Section 149B. Because according to the legislator, the trial judge is the one who eventually decides whether documents must be added to the file or if they have enough information to properly assess the case, and by extension, the trial judge can decide that some documents can still be submitted. Article 315, first paragraph of the Dutch Code of Criminal Procedures. The defense has no role in this procedure of 149B. As such, the role of the council has been eroded and has put the interest of fair process, has entrusted that to the public prosecution service and the investigating judge. It doesn't feel properly, and the fact that the lawyer is considered to be the gatekeeper in our legal system. Now, when they are excluded, it would be reasonable, when the means that are available to the defense, that these would be assessed with some benevolence. Now, these options that the defense has are the options to indeed request the trial judge to submit documents as such. So the opportunity offered by section 315 to 328 of the Dutch Code of Criminal Procedure, that option exists to provide these documents if it is demonstrated to be necessary. I will interrupt you, Mrs. ten Doestadt, because I see messages that the screens on the top floor are not in operation. They do have sound, so you can indeed hear what's happening. Do we need to interrupt, is my question, to solve this matter, or would we like Mrs. ten Doestadt to continue? I do understand that they say, please continue, and we will solve that at a later stage. But it's so interesting what I'm saying. Well, they hear you. But they are concentrated to listen to you. Now, please continue, and when you stop, we will interrupt to solve the matter. I am halfway item 12. Now, Borger states as possible arguments that can be based on such a request that, for instance, it could be argued that facts and circumstances have occurred that lead to the fact that the necessity to shield these documents must now be assessed differently than the investigating judge has done before, or that there are clues that the shielded documents would have discriminating or otherwise beneficial details for the accused, so that continuation of shielding would be contrary to the right to fair trial. By extension, in order to not make it just a formality, this opportunity, it is important that the defense must have some idea what documents are shielded. And in that respect, Borger states that the defense must have an actual opportunity to participate in the decision making with regard to shielding documents, court documents. It is of interest that the following factors are of interest to that. The specific impediments that arose for the defense by shielding the documents, the extent to which the public prosecutor or the investigating judge have explained the nature and or the global or summarized substance of the shielded documents, and in cohesion the specific opportunities for the defense to refute the grounds for shielding, the extent to which the position of the defense has been engaged in different decisions with regard to shielding, and also the extent to which the grounds that were argued by the defense or the questions that the trial judge have been investigated, and also the existence and the use of alternative opportunities to be able to see the shielded information, for instance by hearing a person as a threatened witness. Now, the legislator suggests that the trial judge that must assess such a request should also engage the investigating judge, other than just directly ordering the irreversible publication of these documents. Now, the investigating judge can, also against the backdrop of the vision of the trial judge and the defense, and or new or amended circumstances and or perspectives, the investigating judge can assess the necessity for shielding once again. Now, this could take place in respect of section 316, any investigation by the investigating judge, which could lead to further reports by the investigating judge with regard to the necessity to the trial judge, and the trial judge can then decide on the request by the defense to add. Referring to the above, the defense team requests you to order that the following documents will be submitted by the public prosecution service and next be added to the file. albeit or not after the investigating judge has been requested to decide once again whether shielding is still necessary, observing the following.
This request first concerns the witnesses pursuant to Article 149b of the Code of Criminal Procedure. In the sub-file, there are several requests and orders in connection with witnesses. And for the moment, we have focused on the witnesses of whom your court has established that further interviews will take place. So this is M55 and 4 primo numbers, and these are the interviewing officers that have described how an unknown witness has found certain parts of the missile. So we focused on these witnesses for the moment. Now, that doesn't mean to say that at some point we may request you to add the records of the interviews of witnesses that we have not been referring to so far. M58. The following applies. Parts of all the official reports of his interview and certain mails with the Public Prosecution Service, or the JIT, that parts of that information has been redacted, has not been incorporated, and that has been done on the basis of the idea that the witness would experience inconvenience with respect to the implementation of his profession, and would experience obstacles and serious reasons also with respect to the investigation. Now, the reasons for not incorporating those documents have not been specified. These witnesses, it seems now, are no longer located in Russia or Ukraine, and the investigation, insofar as these facts are concerned, seems to have been concluded. So, there seem to be facts and circumstances that lead to the fact that the necessity to shield those documents should now be assessed differently. Furthermore, we only have an interest in certain documents. It's very difficult to determine which documents they are because we don't know what those documents contain, particularly the redacted parts. But those parts that concern the identity of the witness, so those parts that have been shielded because the witness otherwise would experience inconvenience, we have no interest in that. Furthermore, it is also possible, and it seems to be the case sometimes, that certain parts have been redacted because these are the parts in which there's a discussion of under which conditions the witness would be prepared to make a statement. Now, these parts are necessary for the defense in order to be able to assess the reliability of witnesses. And the interests of 187D cannot justify not incorporating those documents. I'd like to refer, by way of example, to the questions of the interviewing officer that were redacted. One fails to understand, particularly not without further explanation, why incorporating his questions should not be done in view of the interests as stipulated in 187D. In the first interview, and I've referred to the reference in literature in my pleading notes, we can read here that the officer says, fine, first I want to ask you, and then it's redacted. And furthermore, he says, there are 298 people that have lost their lives, and I don't want to have it on my conscience to have an extra victim. Redacted. Witness says, yes, 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 and then the interviewing officer says, redacted. In order to be able to assess what was discussed with the witness, what was asked of the witness, and what he was promised and what he was not promised, the defense counsel has to be able to take cognizance of what the interviewing officer has told the witness and or asked him. And this also applies to the second interview. Here it says the interviewing officer proceeds to ask personal questions, then redacted. And then it says the officer has another question to the witness and then redacted. It's important to assess the reliability of the witness. It's necessary to know what was asked and what the answer was. And this same applies to other redacted pieces or sections that are not strictly related to the identity of the witness. It only applies to those parts that the defense counsel has an interest in. The 4 primo interviewing officers. Now, The defense at the hearing made a request to interview four interviewing officers. Here in my pleading notes it says 23 January 2020. That's incorrect. It should be June, 23 June. So we made a request to interview four interviewing officers with respect to missile parts that apparently were allegedly found in April 2015, and your court granted those requests. By way of preparation of these interviews, the Defense Counsel started looking in the case file for video recordings that were made of, insofar as what we can see, of the indicating the locations in which those alleged missile parts were found. In the first pre-trial meeting before the investigating magistrate on the 25th of August, it became clear to us that these video recordings are most probably excluded from the file. That seemed the case on the 25th of August, that they were not incorporated in the documents on the basis of 149B, and that they fall under the order of the examining magistrate made on the 24th of June 2016. Now, the order itself doesn't specify that because it doesn't really specify the Spock numbers. And there's no further explanation. The public prosecutor, one day after this organizational meeting, informed that the emails are indeed covered, or informed by email that the video recordings indeed are covered by the court order, and that the Spock numbers concern 17, 21, and 40. Now, we read that it has become apparent that witness or witnesses will be seriously inconvenienced or will experience impediments in the performance and or exercise of their profession. And the defense informed the investigating magistrate, or requested the investigating magistrate by letter of 17 August 2020, and requested reconsidering the order made on the 24th of June 2016, or to establish that this was a temporary order. And the request was made to reconsider whether the situation that took place at the time is still exists in August 2020, so after 4 years. So whether this necessity is still at play. And we pointed out that if the video recordings show persons that could be identified, that there are all sorts of possibilities to make sure that that doesn't happen. So the faces of these people could be blurred, for instance. So attaching conditions to this authorization is in line with the way in which the intention of the legislator, according to, for instance, Borges, should be interpreted. And even though the law does not specify that conditions can be attached to this authorization, he says that it doesn't seem incompatible with the scope and the intention of Article 149B if the investigating magistrate should attach certain conditions to an authorization. We could think, for instance, of a situation in which the investigating magistrate agrees with the prosecutor that a certain document should be excluded from the case file, but that they do consider it responsible to disclose this information in some other way. That could mean that certain witness statements could be kept outside the file, but that an official record be made in which the main points of the statement be included. The investigating magistrate has informed us that they don't see any legal possibilities to reconsider the decision to grant this authorization. And this is the reason why, as we just explained, we're requesting your court to decide that these video recordings should be added to the case file, if necessary, after the examining magistrate having certain measures take place, such as blurring, so that certain persons, in view of the interests as laid down in Article 187D, that these people cannot be recognized and identified. The necessity to incorporate these video recordings is evident as far as we're concerned. Most probably, the video recordings show in which way the locations in which the alleged missile parts were found. So these are the parts of which the public prosecution says that those are the parts that help down the MH17. So in which way these locations were pointed out. and where and under which circumstances these missile parts were located, and how these missile parts were secured. And with that, by accessing the video recording, the reliability and the usability of this material for evidentiary purposes, and the same applies to the follow-up investigation that was conducted into the material, such as the Forensic Institute investigation, that can then be assessed. You cannot refrain from doing that and compensate that by interviewing the police officers. Video recordings are more specific, and also if we take into account that memory is fallible and also the passing of time, it's important to look at video recordings because that would be much more accurate than oral descriptions. And then there are a number of other documents covered by Article 149B of the Code of Criminal Proceedings that have not been added to the case file. It's unclear which documents these concern and why one should refrain from incorporating those documents. And this is at odds with a fair trial because, as a defense, we're simply not capable or in a position to assess why incorporating these documents could be necessary. We would request your court to instruct the public prosecution to draft an official report describing the substance and/or the scope of those parts, those documents, the documents that were not incorporated, and under which primo numbers those documents may be incorporated, and why the public prosecution felt that those documents should not be incorporated, and why this is still necessary, possibly. And this would concern the following documents. And with your permission, I'm not going to refer to them all by number. There are just a number of documents that are in the procedural documents 149B camera, and also in the sub-file 149 NFI documents. Now, I am going to, and also 149B seizure, exceptional seizure. These are all documents of which the numbers have been referred to in the case file for all of them, but that's really all there is. So to assess why it's necessary not to incorporate those documents, and also which documents are concerned or whether they're relevant documents, in any case, whether they're necessary in order to be able to comply with the requirement of fair trial. These are documents we don't have access to. I'm just looking at the President of the Court, whether he would like me to read this all out with all the details. The presiding judge, all the exact numbers, no, we can find that in your pleading notes. Defense counsel, for all these documents, I would like to say for the first category of documents that I have specified in my paragraph 32. So this is the documents in the procedural documents camera. In part, these are the documents that I just referred to, the video recordings, but there's much more. And there are lots of documents, for instance, Spock 79, for instance, documents of which we simply cannot see what they concern and what they relate to. And we don't understand why the public prosecution doesn't want these documents to be incorporated, and the documents for which it has been requested that parts be added. So parts of those documents should be in the case file but cannot be found under those Spock numbers. They may be in the case file, but they have not been specified with Spock numbers. So I'm sure another primo number will have been assigned to them, but that is not on the basis of the documents that we have. So we cannot see which documents in part have been incorporated in the case file. So we cannot assess in which measure it would be necessary to add the rest of the documents. The authorization of the examining magistrate, well, I can read that this authorization has been given, but the authorization itself has not been added in the official report in which it says that the authorization has been added, and I cannot see on which grounds that authorization was issued. And then the NFI documents, the sub-file, here we're requesting, or it has been requested, to fully refrain from incorporation of a number of documents, a memo, a number of reports, revision of reports, and also a letter of someone whom I think is an expert for the examining magistrate and other documents, a request for appointment of an expert, and also for the documents concerning Article 149B, exceptional seizure. Here also a number of documents have not been incorporated. For us, it's simply impossible to assess why these documents have not been incorporated and why it would be necessary to incorporate them. Now, in conclusion, and this concerns witness X48. So this is, says the presiding judge, this is paragraph 35 of your pleading notes. Yes, 35, X48. As far as I can see, these are not documents or parts of documents that have not been incorporated pursuant to 149B, but there are other documents. And in the official report of his interview before the examining magistrate, there's a sentence, and this is a sentence that starts with, except for a number of men, there's also one woman in a military uniform. Part of that was redacted. I cannot see who has done that, and particularly we cannot see why that was done. I have not seen an authorization 149B in this part of the file, and we would request your court to order the prosecution to submit the original unredacted official report of the interview. And then also for X48, there's an official report of the National Prosecution Office, and this concerns a statement X48 made before the interviewing officers. The statement that X48 made has not been incorporated in the file, not in the procedural file, but it's only a summary, a brief summary. That's what it's being referred to as. And in this summary, we cannot read, nor can we estimate which parts of the statement have been made spontaneously. We cannot see which questions were raised, nor can we see which information was provided to X48. This summary, in order to be able to assess it properly, and also to be able to establish the reliability of the answers for X48 in later interviews, it's important for the defense to have more of an understanding of the state of play and what happened during this statement that apparently was made. And by way of explanation, when I'm talking about assessing reliability, X48, if at a certain, or later on in a statement he shares certain knowledge, it's important to know whether that has been addressed before in an earlier statement. M58, for instance, we see that in a very early statement, early interview, the interviewing officer asks, where were you, for instance, near Pervomaisky? And so, well, if that is already incorporated in a question, that's important to take into account to establish the value of an answer given later. So it's important to know about this. So the same applies to X48. And this is the reason why we are requesting your court to order the prosecution service to make sure that all the reports, correspondence, other documents that concern contact with and or statements of X48, that those documents be submitted, possibly after asking the examining judge to assess those statements, and if it's necessary to guarantee anonymity of the witness, to possibly in part redact parts of those statements pursuant to Article 226F of the Code of Criminal Procedure, in order to be able to add those documents to the file. Presiding judge, okay, we will interrupt the hearing to solve the technical problems. I'm just looking at the prosecutor. You will respond to this at a later stage, and later on, after the counsel for the relatives has taken the floor, we'll see how to organize this and how and when you can take the floor. Prosecutor, do you mean later today? No, says the presiding judge. We'll discuss that later on, see whether that'll be later today or at a later point in time in the hearing. Prosecutor, well, I can say that these are a large number of requests for investigation, And by and large, these are questions in terms of the file. Well, we could have clarified that should we have received those questions beforehand. We didn't receive them beforehand. It was a decision of the Defense Council to do this unannounced, which is unfortunate because I would think that there are a number of questions that we would have been able to answer quickly. But I don't think that this fits with the planning of the hearing. Would you allow me to make one remark about, says the Defense Council, let me just raise the microphone, about our request not having been announced. With the exception of detail, the vast majority of the documents that we have requested to be incorporated, in the organizational meetings, we already asked those questions to the investigating magistrate. And for instance, the suggestion of the investigating magistrate was to repeat those requests at the hearing. So as far as I'm concerned, it's not necessary to respond to this immediately today. It's no problem as far as we're concerned. If that should be done at a later stage, it need not be today. But should the impression be given that this is unexpected and a surprise, I'd like to highlight that it was addressed before, and also the fact that this could be repeated at the hearing itself. Presiding Judge, thank you. Well, in that respect, I think we have time in the coming hearing blocks. Well, of course, if those questions can be answered in the block of 28 September, if that's fine with everybody, we can do that. But I think that once we've listened to Counsel for the Relatives, I think it's important to take stock of the situation and see how we can proceed with the hearing. Can I make one request? Later on, we can discuss the questions for Counsel for the Relatives. The defense last week wrote about and also addressed that today, the possibility of traveling to the Russian Federation. Last week, Thursday, we received an email in which the defense indicated that it cannot travel to Russian Federation and indicated that it consulted a travel agent that didn't want to plan that. I understand that they have booked a trip now, that they don't know what's going to happen, but they do think that it may happen. On the 18th of August, we informed the Defense Council which cities can be traveled to. Is this better? The prosecutor is adjusting the sound. So, information was given in terms of regular travels to Russian cities, and after the defense indicated that it was not possible to book a trip to Russia last Thursday, we checked with the government what the possibilities are, and these possibilities do exist via several European cities several times a week, and these are not flights that have just started last week or this week, and these are not flights that all of a sudden are cancelled. No, there is regular travelling. Also, employees of the Ministry of Foreign Affairs and other government institutes are travelling. I wanted to highlight this because this is important to take into consideration. We're happy that a trip has been booked, and should there be any problems, we are capable and prepared to help you and to point out which flights leave several times a week through which European cities and by means of which websites they can be booked. So should you need our assistance, we'll be happy to help. Thank you. So now I'll interrupt the hearing. I don't know how quickly we can solve the problem. You'll be informed thereof, and we will then continue with the hearing.
Please be seated. Okay, the session is resumed, and we are now going to hear from the counsel for the relatives. Go ahead, please. I don't know how long you plan to speak for. Well, we've decided that we've to divide our presentation into two sections. I'll do part one. I expect to be talking for about an hour and a half. Then what we have in mind is that that would be a reasonable time to have lunch. After that, Mr. Langstraat will take the second part of our pleading. That will take about half an hour. Okay, so I would think of lunching about 12:30, if that is a reasonable time in your pleadings, and if not, we'll make sure we just get a reasonable time for lunch. Yes, I think I prefer to give my presentation in one go, but if there is a natural time to have a break and I can see that people are beginning to have trouble concentrating, then of course we can interrupt in mid-flow. Go ahead, please. Honourable members of the court and all present in the court today, it is time for the relatives to be heard via us, the counsel for the relatives, so I will refer to it as the team. And that's important for them, although we're not talking about their personal story today. We're talking only about the legal questions put to us by the court. Now, the legal questions are very complicated, and it's easy as the result of that to forget what this criminal trial is all actually about. One of the relatives expressed it to me by saying it very simply. He said, "It's about our loved ones. It's about our loved ones." It's very important to bear this in mind at every hearing and every stage in the trial. This is particularly important when addressing the presentation I will be giving today in response to the questions put to us by the court on the 23rd of March. All the questions are reasonable, but that does not alter the fact that answering these questions, which are extremely technical and legal, incurs the risk that we might lose sight of the beloved victims that we are addressing in this case. Here, by way of presentation, I would like to invite you to remember the people who have lost their loved ones and for whom this criminal trial is much more than simply the right to speak or to submit a claim. The criminal trial is important for them because it will establish the facts of what happened on the 17th of July 2014, who is responsible for it, what sentence they deserve. In other words, it's about justice, fairness, crime and punishment regarding the crime on the 17th of July 2014. Now, in my presentation, which is in two sections, I will be addressing the following points in my section, which is section one. Firstly, I'll be talking about the purpose of the criminal trial for the relatives. Secondly, I will discuss our team's response to the questions put to us by your court on the 23rd of March. Here, I will be dealing largely with the principle of the interplay between the criminal code and the civil code. And having addressed that interplay, I will then answer your two questions regarding jurisdiction and adhesion. I will then talk about which law is of application. As an extension of that idea, that is to say the applicable law, which is civil law, is of application, I'll also say something regarding about the excessive burdening of this criminal trial, whether the application of foreign law would overburden the trial. Then I'll deal with the practicalities regarding planning and structure of the debate between the parties regarding the claims to be submitted. And in section 2, as I said earlier, Mr. Langstraat will talk about the current inventory we've discussed with the victims regarding their rights and how they wish to exercise them. First, though, I'd like to address this question of who the relatives are in this case, and what they really want from this trial. Now, we've heard a lot in the trial already about the relatives. And today again, we are talking about the rights which they can exercise in this criminal trial. It's important to remember again and again, we're not dealing with a homogeneous group of people, all of whose wishes and hopes are much of a muchness. No one can be downgraded to simply membership of a group, in this case, the relatives, against their will. No, we're dealing with individuals who've suffered a terrible loss 6 years ago, a loss that they still feel in their daily lives now. The consequences of what happened 6 years ago are what they still face. All these people have a personal story. And with our team, on Saturday the 22nd of August, when we had a big meeting with all the relatives, we heard all their stories once again. And we heard the urgency and the importance of these stories. They've all got their own wishes, their own hopes, their own needs regarding this criminal trial. And when one of the public prosecutors on the 9th of March, when the criminal trial started, listed all the names of the fatalities, that was of great importance to the relatives. They would like to thank the prosecution, through me, most sincerely for this gesture. They could see that their individual grief was recognised on that occasion. They're also grateful for the way in which the prosecution so far has carried out its enormous duties regarding investigation and so on. They're also grateful to the respectful way in which the courts has treated the relatives in this case. Now, it's not only the relatives for whom it's important not to be seen as a uniform group of people. The same applies, and perhaps it applies even more, to the defendants in this case, and for all the other people responsible for downing MH17. In the criminal trial, every person is accountable individually. No one can evade this because he belongs to a particular group or movement, or by pleading orders from above. Every individual, both in war and in peace, every individual bears individual responsibility for his actions. That being said, in my presentation, I will not be able to avoid using the term the relatives, referring to them as a group, because that is the terminology which best suits the legislation. As I said, the term really does not reflect the diversity of the group of relatives and each individual suffering. However, we take the view that what we are saying today, what we are saying enjoys the support of at least most of the relatives that we are representing here today. I now would like to move on to the question of the heart of this criminal trial from the relatives' point of view. Your court asked us questions on the 23rd of March concerning issues regarding claim for compensation. But compensation is not in and of itself the purpose that the relatives are pursuing. First and foremost, they are seeking some kind of redress for the injustice that was carried out on the 17th of July 2014, as much redress as possible. And the payment of compensation is one way in which redress can be achieved. Reparations are not the purpose in themselves. They are a way of achieving a higher purpose. And for that reason, the term reparations is a much better indication of payment to compensate for injustice. And it's not, there is indeed a reason. This isn't in my notes, by the way. Last Wednesday, Minister Dekker said that a compensation of money was being made available, and he said explicitly it was not compensation. He said it was recognition of victim suffering. In the light of this, it's not so much the compensation for harm, it is rather reparation and redress in combination with enforcement of the law. We know from a growing body of research that victims of physical injury and their relatives have needs above and beyond compensation. People who have been harmed by another person's deeds often seek redress through, for example, the facts being established, responsibility being acknowledged, and understanding what exactly happened. The offering of apologies, and making sure that consequences arise from what has been done. Of all these remedies, establishing the facts is of greatest importance for the relatives. They want to know what exactly happened prior to and at the moment of the downing of the MH17. Establishing the facts is very complicated in itself because the scene of the crime is a war zone. As the prosecution has explained at great length already. But establishing the facts is particularly difficult in this case because of the complicated political situation where we face obstruction and disinformation from the Russian Federation. Now, Russia is a country where one of the greatest writers in history has written books about how to deal in good conscience with crime, and that makes Russia's attitude remarkable, to say the least. But we're not here to discuss literature. We're talking here about people of flesh and blood. In addition to the grief they face because of the loss of their dearest, they are additionally injured by Russia's attitude. It is therefore of great importance to the relatives that both the people who bear the ultimate responsibility for downing the aircraft and the people who substantially contributed to that should be called to account in a trial which is deemed to be just. And for the relatives, part of justice is to make sure that they can avail themselves of their rights as victims, they can tell their story, and they can take an active part in the trial. And this criminal trial is an ideal opportunity for them to meet these intangible needs. In summary, the first thing then is that compensation, as I said, is not the objective in itself for the relatives. It is simply a means of achieving a higher goal, that is to say, some kind of redress. Some kind of redress. The payment is only one way of achieving this. Also, being able to take part in the trial, calling people suspected of involvement to account for the death of their nearest and dearest. These are all important in today's criminal trial. What this is not to say that claims being submitted do not mean that, beg your pardon, this is not mean to say that the parties don't attach great importance to their claims being considered. Neither does it mean that they can accept compensation as a form of a symbolic payment. It's important to make a distinction between the compensation, which will always be partly symbolic, after all, money won't bring their relatives back, and the scale of the compensation. If we want compensation to be reasonable and a genuine symbol of the defendants shouldering the responsibility for their own actions, then the compensation must reflect the seriousness and the importance of this crime and its consequences for the relatives. My footnotes here refer to a recent court ruling regarding EU law, reflecting just what I said a moment ago. I now come on to our team's response to the questions of the 23rd of March 2020. The first three questions put forward by the court deal with the interplay between the civil law and the court rules of civil procedure and the criminal law and the code of criminal procedure. And there's also aspects of international private law here. And that is why we brought in three experts to look through these questions with us. There's Professor Dr. Van Hoek, Professor Van der Plas, and Mr. Dieben. They have given us a legal written opinion, and we have made it available to the court, the defence, and the prosecution. I will now omit paragraph 16 of my notes and move on to paragraph 17. In order to avoid unnecessary repetition, I will not go through the whole of their opinion, but I think it is in the public interest for me to run through a number of points and explain them further. I think it's everyone's interest to discuss these issues at today's public hearing. The relatives have also received the written opinion, but it's so complex and long, I suspect many of them won't have read it. Other interested parties in this case are also entirely unfamiliar with this opinion. The main conclusions the experts come up with are fully accepted by the team. Our opinion does not differ from that of the experts in their written opinion. What I would like to do is add something to their written opinion and discussing the compensation order and how it can be implemented. And the question of applicable law, I will add to their written opinion by making a suggestion on how foreign law can be found and the way in which the debate between the parties can be given meaningful shape. The first question is whether your court has jurisdiction to rule on civil claims. In particular, the court asked whether this jurisdiction arises from its criminal jurisdiction over the case or whether the two jurisdictions should be seen as distinct. In the latter case, the court has asked for our opinion regarding its jurisdiction in civil matters. Now, before I move on to answer this question specifically, there's a preliminary question we need to look at, which is how the criminal and civil codes of procedure relate to each other. I've got them both here with me. What we can see here is the relationship between the two codes of procedure. Or you can see the criminal code of procedure is much longer than the code of civil procedure. And that is relevant, of course, when we come on to talk about the adhesion procedure. These are questions of principle question. And this preliminary question then is the interplay between these two fields of law. And that is what gives us the answer to the first two questions. Regarding the substantive aspects of the injured party's claim, is quite clear here. It is the civil code which applies. But what about the procedural aspects of the claim? Is it still the Code of Civil Procedure that applies in the adhesion procedure, unless explicitly specified otherwise? Should the Code of Civil Procedure be applied mutatis mutandis only when there are gaps in the Code of Criminal Procedure? Or is it quite impossible to apply direct or mutatis mutandis application of the Code of Civil Procedure, in addition to or together with the Code of Criminal Procedure? Now, the experts have given us a very clear reply to this. They did this on the basis of in-depth study of well-established and recent Supreme Court rulings, and also the Tovey Act, also known as the Victims' Criminal Compensation Act, which extended the adhesion procedure and introduced the question of compensation rulings. And here they say that the procedural aspects of the adhesion procedure are fully subject to the Code of Criminal Procedure. It is not possible to apply the Code of Civil Procedure directly or mutatis mutandis, unless there are one of two cases. One is if there is a provision in the Code of Criminal Procedure providing a link between the two, or if the drafting history of the law make it clear that the legislator explicitly wanted the Code of Civil Procedure to be applied mutatis mutandis. In other cases, it is the Code of Criminal Procedure which applies. Now, regarding the first case, the first type of exception, where there is a linking provision, you can find some examples in the Code of Criminal Procedure. The articles deal with criminal account preservation, and in those articles there are many references to the Code of Civil Procedure, and those provisions are declared to be of application on that part of the criminal proceeding. Another example is Article 421, which talks about an injured party's right to appeal if their claim has been rejected. In Article 421 again, a number of provisions from the Book of Civil Procedure are explicitly said to be applicable to the criminal case. Now an example of the second category, that is to say, where the drafting history of the law appears to make it applicable. An example here is the legal costs ruling, which is Article 592 of the Criminal Code. It's now 532. Here, the Supreme Court interpreted this by analogy with Code of Civil Procedure, because the parliamentary debate surrounding the Victims' Compensation Act made it clear that the legislature wanted to make sure that there was no gap between the civil procedure and the adhesion procedure. In all other cases, it is only the Code of Criminal Procedure which applies. The main purpose of this conclusion is the consistent Supreme Court rulings, which have consistently rejected the addition of rules of civil procedure that apply in a civil case to complement the Code of Criminal Procedure. And in my pleading notes, I won't go through it all. I list a number of aspects where the Supreme Court has already ruled to this effect. In establishing the procedural embedding for these questions, the Supreme Court refers exclusively to the Court of Criminal Procedure. The Supreme Court always points out that the application was auxiliary to the criminal case, but also that it is clearly, or apparently, the wish of the legislator, the explicit wish of the legislator, that the criminal procedure, the adhesion procedure, should provide a process which is as approachable and simple as possible. We can also see from the historical background of the Criminal Compensation Act that the Code of Civil Procedure does not apply to the adhesion procedure. I would refer you to the written opinion from Yahe, our experts, for further detail on this matter. So the conclusion regarding this preliminary question is that procedural aspects of the injured party's claim are entirely subject to the Code of Criminal Procedure. The only exceptions are if the law explicitly states that civil law applies, either by having a linking provision or by this being clear from the history of the Act. This conclusion then gives us the framework where we can assess the first two questions from the court. Firstly, criminal court's jurisdiction over civil claims. The international jurisdiction of the Dutch courts to rule on civil cases is set out in Articles 1 to 14 of the Code of Civil Procedure. The Code of Criminal Procedure does not provide any link to those articles. There's also no indication that the legislator intended any mutatis mutandis application of these provisions. On the contrary, the legislature took the view that these civil rules of jurisdiction did not apply to the adhesion procedure, and in the expert opinion, there's extensive explanation that the parliamentary history of the Victims' Procedure Act makes it clear that the adhesion is deemed to breach the relative and absolute jurisdiction of the civil courts. Nothing suggests that this would be different when dealing with international jurisdiction. In their opinion, the experts also show that direct or mutatis mutandis application of the jurisdictional rules under the rule of civil code in international cases runs counter to the very purpose of the adhesion procedure. The procedure's existence is justified by the fact that the actions being considered in a criminal trial are first and foremost important because they have harmed the interest of the victim. There is therefore good reason to offer him, where possible, the opportunity to present a civil claim within the criminal trial. End of quote. And the legislator of the MH17 Act also took the view that it is your court's criminal jurisdiction which confers jurisdiction to assess the injured party's civil claim. When the MH17 Act was being discussed in Parliament, the Minister responded to questions from members of Parliament that victims have the right to present their claims as injured parties as part of the criminal trial. The court's international civil jurisdiction, therefore, does not need to be established separately. If your court takes a different view, then our expert opinion also presents a secondary point, pointing out the possibility in that case for the court to assess the injured party's claims on the basis of Article 10 of the Code of Civil Procedure. This article says that a Dutch court has jurisdiction if it arises from other legal provisions identifying a competent court. Those rules are known as the distribution and attribution rules. The international jurisdiction therefore arises from internal rules regarding relative jurisdiction. In today's case, this means that jurisdiction can be based on Article 10 Civil Code, together with Article 51 of the Criminal Code and Article 2 of the MH17 Act. This is also in line with the drafting history of Article 10 of the Code of Civil Procedure and also supranational rules, such as the Brussels 1A regulation. And the prosecution has already referred to Brussels 1 regulation in its when it was speaking earlier. So the conclusion regarding question 1. The court has criminal jurisdiction over the MH17 criminal case, which also confers jurisdiction to rule over the injured party's claim. At a subsidiary level, the international jurisdiction, well, if the court takes a view that it does not have direct jurisdiction arising from its criminal jurisdiction, it can establish its international jurisdiction on the basis of Article 10 Civil Code, 51 of the Criminal Code and Article 2 of the MH17 Act. I'll now move on to the compensation order, because the question of jurisdiction, which was correctly raised by your court, addresses only the question of whether the court has jurisdiction to rule on the injured party's claim, but that does not alter the fact that the court, quite separately from any injured party's claim, is in a position to apply the compensation order. And in this question of applying the compensation order, the question is not one of the civil jurisdiction. The experts draw our attention to this, and I'm going to go into this in some more detail, because there's a great deal of case law and also recent ruling from May last year, in fact, showing that the compensation order is entirely separate from injured parties' claims, inasmuch as even if a claim from injured parties' claim is deemed inadmissible, or even if no injured parties' claim has even been submitted, the court is still able to impose the compensation order. The only criterion here is that the defendant's guilt has been established according to civil law. In my pleading notes, I have a number of lower level court cases. With your permission, I will not read them all out. I simply refer you to them. I also refer to 4 Supreme Court cases, sketching out the same background again and again. We could really say there is consistent case law from the Supreme Court, always saying that the compensation order is completely separate from other matters. And we can see that the compensation order is entirely independent in legislation. For example, in the explanatory notes to the Innovation Act on Criminal Code, we can see that the imposition of the compensation order does not require that a victim has joined the criminal case as injured party in order to get compensation. What I've just said also applies to the application of a partly conditional penalty, with, for example, a ruling that compensation must be paid to the victim. This is Article 14C. I'll now move on to question 2 regarding in absentia. Now, your court asked the question regarding 2 decisions to try in absentia, and asking whether these should coincide in assessing an injured party's claim. Here again, the framework against which we judge the question is important. This is the interplay between the two fields of law. And here, again, the framework that I explained earlier answers the question. There is no linking provision in the Code of Criminal Procedure making it possible to apply the Civil Code 139 to 142 mutatis mutandis. No, there is no linking provision to these articles, and the drafting history of the law also doesn't suggest that the legislator intended civil law to be applied mutatis mutandis. Furthermore, the history of the law indicates that the legislator considered that it should only be criminal in absentia rules that apply to the adhesion procedure. During the parliamentary debate on the Victims' Compensation Act, this question was raised. What if a suspect in a criminal case does not turn up and is tried in his absence? Can an injured party's claim still be considered? And the answer is yes, it can. You can see this in the explanatory notes on the Victims' Compensation Act, even if the suspect is not aware of the injured party's claim, perhaps because the defendant has no fixed abode. Now, a legitimate question, therefore, which is one, in fact, raised also at an earlier stage by the prosecution, how last May's Supreme Court clarification ruling should be read against the background of your question regarding in absentia trial. And the question is very relevant because in the clarification ruling, the Supreme Court outlined the legal provisions which are important to the adhesion procedure and mentioned Article 139 of the Civil Code, among others. This is the in absentia provision in the Code of Civil Procedure. And our YAHE experts, in their written opinion, looked into this question, and they have convincingly showed the clarification ruling does not, in their view, imply that the civil rules on an absentia trial should be applied mutatis mutandis. And one of the main reasons for this, which is very reasonable, is that the Supreme Court makes the reference to Article 139 as a key matter in assessing the court's decision if the injured party's claim has not been challenged. This is particularly Section 283 of the explanatory ruling. In that case, Article 139 of the Code of Civil Procedure, the court will generally grant the injured party's claim unless it takes the view it is unlawful or unreasonable. The Supreme Court does not repeat the key provision, Article 139 of the Civil Code, in its ruling, 139 being absentia and not appearing. It therefore follows that the reference to Article 139 does not indicate that the civil rules on in absentia trial must be applied to adhesion mutatis mutandis. This is very much in line with consistent Supreme Court case law regarding the obligation to furnish facts and provide evidence and the motivation for a decision. The experts then continued from that question regarding in absentia trials to consider the question of what should happen and how a defendant should actually be informed that there is a claim for an injured party, and what the consequences could be if the defendant is not aware of the claim. Now, the experts take the view that the principles of due process and Article 6 of the European Convention of Human Rights do not prevent the claim being considered and granted. I won't repeat their reasoning here, but they do point out that it is advisable for the prosecution to do everything it can to inform an absent defendant in due time that there is a claim and what it says. I'll come back to this in a moment when I discuss more practical matters regarding the timetabling that our team has in mind for submitting injured parties' claims. So the conclusion regarding question 2 is that the rules on in absentia trial are entirely subject to the Code of Criminal Procedure. That allows only one such decision, which is Criminal in absentia trial, Article 280. There is no mention of abstention, of civil in abstention trial here. Now your third question. Which civil law is of application when dealing with an injured party's claim? And the framework for assessing this question arises from the Rome II regulation. This says that the law which is of application is the country in which the harm was caused, irrespective of the country where the indirect consequences of the event are felt. So we're talking here about the primary damage, and that is the death of the MH17 passengers. MH17 was downed over Ukrainian territory. It therefore follows, in the light of Article 4, Section 1 of the Rome II regulation, that Ukrainian law is of application. The experts also dealt with the question of whether there's any rule to apply any of the exceptions to Article 4, Section 3 of Rome II. That is to say, the closer connection exception. This exception is very narrowly worded and is only relevant if there is a, quote, manifestly closer connection with the legal system of a different country. Now, in order to go further into this exception, whereby it might be possible to apply Dutch law to the claims, the experts refer us to the nationality of most of the victims. Most of them are Dutch citizens. And they also draw attention to the point of departure of the MH17, Schiphol Airport in Amsterdam. They also pointed out that the countries investigating the case together in a jet all agreed that the case should be tried and prosecuted in the Netherlands. That could be an argument for applying Dutch law. But the experts nevertheless came to the conclusion, in the light of this all, that although it can be argued that the closer connections exception could lead to Dutch law being applied, but the arguments in favour of the exception clause are insufficiently cogent. What they thought was a deciding factor here was that this is different from aircraft crashes arising from technical defects. Here, the MH17 was downed, and this is very much in the light of the background, which is armed conflict on the ground. The place where the MH17 was downed is Ukrainian territory. That is where this is where the harm was occurred. This is the scene of the crime, and that is not a coincidence. The experts also pointed out that there are some factors which could indicate that Dutch law is of application. It does not apply to all the victims. And in my notes, I've listed the nationalities of all the victims of this event. So conclusion regarding question 3 then is that on the basis of Rome II, Ukrainian law is of application. I'd now go on to another question from your court, which is how this Ukrainian law can be established, and also how a debate between the parties regarding the claims can be structured if it is to be assessed according to foreign law. And how it can be structured in such a way as to make sure that all parties' interests are duly guaranteed.
But first, I think it's appropriate to say a few words about a question that will surely arise, the question whether applying foreign law would constitute a disproportionate burden of the criminal procedure. The question may be premature on the one hand because no claims have been submitted yet, but on the other hand we know, because we've taken stock of the opinions, and Mr. Langstraat will be discussing that in a couple of moments, that quite a number of relatives have indicated that they're considering to submit a claim. So it's not simply a theoretical exercise. Our position is that hearing the claims in civil claims would not lead to a disproportionate burden of the criminal proceedings. Applying foreign law and the number of claims are not an impediment for hearing these claims. Let me explain. First of all, if we want to assess the question whether there is a disproportionate burden, we have to look at the interplay, the proportionality between the complexity of the criminal proceedings and the civil claims. And if a criminal case is more complex and involves more time, we must make sure that that the burden of a civil claim may not be the reason for a Dutch court not to hear those claims. So proportionality here is a key notion. Needless to say that these proceedings from a criminal law point of view is very complex and will take a lot of time, be very time consuming. We've already had 10 hearing days, and compared to that, the claims as such cannot be considered to be a disproportionate burden. Furthermore, Ukrainian law, unlike other countries where international crimes may have taken place, is not considered to be an inaccessible legal system. For parties, by means of legal opinions, but also for the court, it'll be feasible to understand the interpretation and the substance of Ukrainian law and to establish it. And the court can be assisted by experts such as the International Legal Institute, and I'll be discussing the details in a couple of moments. And third, the third aspect that is important to answer the question whether or not this involves a disproportionate burden. If we look at earlier rulings concerning civil claims that had to be assessed under foreign law, we see that there are examples in case law in which the criminal court has not seen the applicability of foreign law as an impediment to assess the claims. In my pleading notes, I'm referring particularly to the ruling of the Court of The Hague, 15 December 2017. This concerned claims that had to be assessed under Ethiopian law, and also a ruling of the Court of Appeal, The Hague, of 7 July 2011. This was Rwandan law that was applicable to the claims. And in both cases, the claims were assessed under foreign law. In addition to all this, and also in the context of the parliamentary debate on the MH17 Act, or in any case, the letter of the Ministry of Justice dated 7 January 2019 makes it clear that the minister also assumes that these claims can be submitted in these criminal proceedings and that there is no a priori, no disproportionate burden. And I'm quoting this: a possible application of foreign law as such is not a reason to earmark these claims as being a disproportionate burden to the criminal procedures. Well, end of quote. And also Public Prosecution Office, in its written opinion of 27 May 2020, already took the position that applying foreign law does not a priori mean a disproportionate burden to the criminal proceedings, in which connection the public prosecution has also referred to the ruling that I just read out. In addition to the aforementioned, we should also consider one other thing, and that is the instruction the legislator gave to the court, and I'm referring to the Victims' Compensation Act that provides for this possibility to submit claims. And here the legislator wanted an easy access to criminal courts for those who suffer damages as a consequence of criminal offences. And the goal of this act has been referred to on several occasions over the past decade. In 2011, this criterion that the claim should be of a simple nature was changed into this term of disproportionate burden, in order to make sure, this is what we read in the explanatory note, that the criminal court, more often than is the case now, be able to judge the merits of the claims of the injured parties. And that the legislator also envisaged complex claims becomes clear if we read the letter of the minister that the minister wrote to Parliament on 26 June 2018 about victims policy. And I'm quoting from that: compensation is one of the core needs of victims, and therefore I'm focusing on expanding the possibility for victims to recover damages. And therefore I want to make it possible that more complex claims for damages of victims be dealt with more often and more completely, and that the advance payment scheme for victims be continued, and that the recourse of injured parties be improved further. And with all this, I envisage to contribute to the recognition and reparations for victims, and that this intention of the legislator also implies an instruction to the criminal court becomes clear if we look at this clarification ruling of the Supreme Court that I referred to earlier on last year, May, in which the Supreme Court, and I'm not going to read out this quote, but the Supreme Court refers once again to the importance of victims being able to be compensated. The Supreme Court has said that the victims should not only have these rights in theory, but should also be able to actually enforce those rights in the criminal proceedings. And this is indeed what the European Union law focused on. In the Netherlands, Dutch legislator isn't the only one at play, because we also have European Union law. We will also have to adhere to European Union law. I'd like to refer to the conclusions of the Council of the European Union took in December last year with respect to the rights of victims. And the Council here once again emphasizes the importance that the rights of victims be maintained so that they can actually enforce those rights in the criminal proceedings, because otherwise this right would mean nothing. And the Council also highlighted, I'm quoting, it's important that victims actually notice that their rights mean something. And the Council also considered that compensation of damages suffered by victims is one of the basic rights, fundamental rights of victims. And in the context of the Order for Compensation and Advance Payment Scheme, it's also important to take into account what the Council stated with respect to the role of the government. The government should also provide for compensation should the perpetrator not be able to do so. The Council said even though the obligation to compensate victims is an obligation borne by the perpetrator, in the close future one has to make special efforts in order to make sure that that victims receive compensation from the state. And in the Netherlands we already have provided for that in these advanced payment schemes that we have in the Netherlands that don't exist abroad. Conclusion therefore is that applying foreign law is not automatically a disproportionate burden for the criminal process. But I'd like to add another aspect to this, because even if your court should rule that these claims do constitute a disproportionate burden to the criminal proceedings, the law does not obligate you to disregard those claims. So even if the claim entails disproportionate burden in these criminal proceedings, they can be considered, because Article 361, Section 3 of the Civil Procedure says that if the claim is disproportionate, a disproportionate burden, the court can disregard it, but doesn't have to do so. So it can be considered nonetheless in the criminal procedure. The court has the liberty to do so. And these aspects and these arguments to, even if the claim is disproportionate burden, to take them along and to hear them, those arguments, there are many of them. I'm just going to highlight one, and that is the importance for the victims to have these claims considered in this court. And first of all, this importance is immaterial in the terms of pain and suffering. It's important to make sure that the crime and compensation, crime and punishment, remain together in criminal proceedings. And furthermore, in criminal proceedings, unlike civil proceedings, offers a possibility of compensation order and an advance payment scheme. And of course, in criminal proceedings, parties can get a ruling that can be enforced, or it's questionable whether it can be enforced, but in the criminal proceedings we also have the compensation order measure and also the advance payment measure. And this is something that we cannot achieve by means of civil proceedings. I'm going to proceed to my paragraph 70. Assessing a claim for compensation within these criminal proceedings is urgent for yet another reason. As we've just explained, the Dutch Criminal Court has international jurisdiction in order to take cognizance of civil claims, but it's quite different for civil law courts because they don't have jurisdiction to rule on claims in this case. Because Article 10 does not provide jurisdiction for the civil court. The only possibility, the only jurisdiction is the forum necessitatis provision of Article 9, B and C. But the experts that we consulted have highlighted that this provision is interpreted in a very restrictive way, and in case law and the administration of justice is only applied by way of exception. So chances are that the civil court cannot derive international jurisdiction from this provision with respect to claims of injured parties in this case. To put it differently, relatives have no other option to recover damages from this suspect than in these criminal proceedings. And for these reasons, we would request the court, within the limits of what is possible, to do its utmost to judge the substance of any claim submitted in these criminal proceedings. And to make this possible, we have reflected on the way these claims could be heard, these claims for compensation, without constituting an undue or disproportionate burden. Well, now I'd like to address the practical point. How can we establish foreign law, and how can we organize the debate between parties about foreign law? And we have some notes on paper, some things that we feel are practicable. The position of this marching route, really, that we're asking your court to issue an interim decision, particularly with regards to question 1 and 3, the jurisdiction and applicable law. And we hope that in the course of this block of hearings, your court would have the opportunity to take such an interim decision. And we're assuming applicability of Ukrainian law, and we would then be able to start drafting these claims with a legal opinion of an independent and internationally renowned law firm in Ukraine that will be able to advise us on relevant aspects of liability and compensation law under Ukrainian law. We expect that the time we would need in order to draft these claims would approximately be 4 months. And this obviously is a period that is quite uncertain, because we're quite dependent upon external parties that will have to explain Ukrainian law to us. And assuming that these external parties will be able to proceed with some expedience in advising us, we would assume that we would be able to draft those claims within a period of 4 months. So that would mean that in early February 2021, we would be in a position to file these claims. And around that time, the Public Prosecution Service might be able to make sure that those claims be notified to the suspects, and particularly the suspects that have not appeared. And then the prosecution and the defense can then be given a period of time to respond to those claims. And we have looked at the periods that have been established in civil law, first a period of 6 weeks, and subsequently in the civil procedures, a delay can be given, a postponement can be given, and so there would be a total of 10 weeks for the defendant to be able to respond to, in writing, to a claim. And in view of the application of foreign law to the claims, and also the possible need of on the part of the defendants to also be advised on Ukrainian law, we would think that a period of 10 weeks would be reasonable, also in view of the need to hear both sides. A written exchange of positions, it happens very often in civil proceedings, will in any case foster the simplicity, understandability of the claims, and the most important matters of dispute between parties will become clear. What is undisputed will also arise, after which there can be a streamlined debate about the matters in dispute at the hearing. And that way, this written exchange of positions will not only contribute to the quality of the investigation and hearing at the hearing, but this written round can also shorten the hearing. And in my pleading notes, I've referred to a case, a linesman case, before the Court of Appeal in Leeuwarden, which ordered such a written round of exchange of opinions. Should the written reaction of public prosecution and defense show that certain items or issues in Ukrainian law are being disputed, then those specific matters of dispute can be submitted to an expert to be appointed to that effect. And we could, for instance, think of the International Legal Institute, and the court can obviously ex officio submit questions to the International Law Institute. The International Law Institute, by excellence, has the knowledge and the expertise in order to answer questions regarding the substance of Ukrainian liability and compensation law, and given its history, would be familiar with reporting in the context of judicial procedures. In order to formulate draft questions to the ILI, the court can give parties 2 weeks time to do that. That would be in April 2021, and the court would then possibly be able to appoint the ILI after 2 weeks, 2 weeks after that, as an expert, or to make use of the possibilities offered by the ILI without appointing it as an expert. So this could be 10 May 2021. So submitting questions to the International Law Institute. The period within which the ILI can report depends on the nature and the number of questions submitted, and we're assuming that a period of 8 weeks should be realistic for the International Legal Institute to do so. And that would then mean, if all this can be done according to this timeline, on the 5th of July 2021, we could expect an advice or an opinion from the International Law Institute. This timeline would then allow for these claims to be heard orally at the hearing block that has been planned for September 2021. And we're assuming here that the Relatives Council will be explaining those claims on behalf of the relatives that obviously we represent. Well, I have included in my pleading notes a schedule of this timeline, which has also been added separately as an annex to the pleading notes. There's ample time between notifying the substance of the claims to the accused, this would be February 2021, and hearing the claims at the hearing September 2021. That ample time will also make sure that there is that we can hear all parties involved, and will also make sure that we will not be dealing with a situation in which the court, as has been formulated by the Supreme Court, that we'll be avoiding a situation in which the court will not consider that parties have not had sufficient time to put forward their positions. So that way we can prevent that this not considered to be admissible. I already said it, we would very much appreciate it if your court would be able to take an interim decision with regards to the questions put forward by the court, questions 1 and 3 particularly, because that way we will be able to proceed to file the claims. Because if your court unexpectedly would decide that there's no jurisdiction, then it would be quite useless to draft the claims, and the same applies for the questions concerning applicable law, because I'm assuming that Ukrainian compensation law will in some respects differ from Dutch law, and so presumably the nature and magnitude of the claims and also the circle of persons entitled to file claims will be quite different under Ukrainian law than Dutch law. So that would mean that for us it would be extremely practical to know how to draft these claims, under which law particularly. So this as far as questions 1 through 3 are concerned. And this brings me to question 4, namely the question raised by your court whether payments have been made by others not being the accused and whether there are any rulings issued against the accused. Now, these questions consist of 2 parts. First part, whether there are any institutions that have proceeded to compensate part of the damages. The court referred to the example of Malaysian Airlines. Second question is how many rulings have been issued by other courts ruling on requests for compensation between injured parties and the accused, and the court referred to the example of a ruling of court in the United States. First part of the question, payments by third parties. This question, raised by the court, obviously is quite legitimate. Prior to answering this question, I think it's a good idea to dwell on the great importance that victims or relatives of the victims attach to compensation by the perpetrator himself. In literature, a lot has been written about this essential need of the victims. Captain refers to this and has summarized it very succinctly. Damages for victims also consists of reproaches to perpetrators. Victims not only want their damages to be compensated, but particularly want perpetrators to do so. And the accused in the criminal proceedings have not compensated relatives in any way, nor have they provided any form of satisfaction, done anything for the relatives. This criminal proceedings is the only possibility to ask satisfaction or compensation from the perpetrators. Mr. Langstrater will discuss the intention of many relatives to submit and to file claims against the perpetrators should be considered against the background of this essential need to get redress and compensation from the perpetrators, because it's only the accused that can provide this compensation in relation to the victims. Third parties can simply not do that. And now the answer to the first part of the question. Your Honours, we have interpreted this very broadly. It doesn't only concern compensation of damages that possibly have taken place, but also damages that do not serve to compensate for damages, but more an expression of societal solidarity or to put an end to a dispute. As far as we know, 3 parties have already made payments to part of the relatives. First of all, this is the donation made by Petroleum, a Malaysian state oil company, Petronas, shortly after the disaster, the downing of MH17, even the day after, announced to establish a fund in order to give a one-off donation to the relatives of the victims. And this donation was an expression of solidarity and compassion. Petronas followed up on this promise, and shortly afterwards this established a fund, KEM, for MH17. This was actually established, and the amount and money was transferred to the fund. And Petronas also called on other industrial companies to transfer funds to this fund. And the fund then voluntarily and upon its own initiative provided donations to those relatives that submitted requests thereto. And the relatives did this themselves, and the members of the Relatives Council team did not contribute to this, did not help. And this was a lump sum. And now the payment by Malaysian Airlines. A large number of relatives, as we've been able to read about in the media, have received payments from Malaysia Airlines. The relatives involved have had to sign an agreement to that effect. Part of that agreement is the arrangement that the relatives involved do not disclose the conditions of their settlement agreement. So this is a very strict confidentiality agreement, which is part and parcel of the settlement agreement. So it's, the relatives are not at liberty, nor are we, to comment on the basis, the substance and the magnitude of the payment and the conditions attached thereto. Should the court at some point in the procedure consider it to be important to know more about the conditions of this agreement, this payment, then the parties involved in the agreement will only be able to do so, to provide information, pursuant to an order by your court. In the view of Relatives Council, further debate at this point in time about payments affected by MAS, Malaysian Airlines, in this stage of the procedures in which no claims have been filed, would be premature. And furthermore, we do not know whether it would be relevant for Ukrainian law whether or not payments have been affected by third parties, whether it's relevant to establish the compensation to be paid for by the accused. Just to be complete, I'd like to highlight that the Netherlands Violent Offences Compensation Fund has not made any payments to the relatives, and the Act only refers to crimes committed in the Netherlands or on board of Dutch vessels or aircraft. And downing the Malaysian flight MH17 above or over Ukrainian territory is beyond the scope of this Act. This brings me to the second part of the question. Are there any other rulings? Have any other rulings been issued by other courts with regards to the accused that are also involved in these criminal proceedings? Answer to the question is yes. A limited number of relatives, 23 to be specific, with an English lawyer. The members of the Relatives Council team were not involved, started civil law proceedings in the United States. And the complaint there was based on the Torture Victim Protection Act and the infringement thereof. I have a quote in my pleading notes. The procedure was only focused on the accused, Mr. Geerken, and he did not appear in the proceedings, nor did he present a defence. And there was a judgment in absentia which was issued on September 6, 2017, in which the claims of the relatives, the 23 victims, were in part granted. And Geerken was also sentenced to pay punitive damages. Should your court wish to take cognizance of this ruling in absentia and the names of the relatives who started litigation in the United States, then we can provide an overview, provide your court with an overview thereof. These rulings in absentia, after authorization to that effect by the American judge, have been served through Facebook, and therefore these rulings are irrevocable. The rulings have not been enforced. The question is whether that's going to be possible ever, because Geerken is on the international sanction list, and the chances that relatives will receive a payment from Geerken is next to nothing. And it's important to consider this. And Your Honour, you referred to this earlier on in your explanations, that a foreign ruling may not be enforced in the Netherlands. Based on Article 431, Section 2 of the Code of Civil Procedure, requires that new proceedings will have to be started in the Netherlands, and then a Dutch court will have to decide whether recognition conditions have been met. And one of these conditions is jurisdiction, whether the jurisdiction of the court that has issued the ruling, the American court, whether that basis is based on a basis for jurisdiction which, under international standards, is generally acceptable. And given that ground, it's not very probable that a Dutch court will rule that the American rulings in absentia can be enforced in the Netherlands. If the court, and this is my paragraph 105, should the court rule that the jurisdiction of the American court is based on a basis for jurisdiction which, according to international standards, is acceptable, and the ruling has come about in a proceedings that complies with the requirements of due process, the question then is whether the ruling is entirely or partially incompatible with Dutch public order. And I already said this. In the American ruling, punitive damages were imposed, and they are considered to be incompatible with Dutch public order. So in that respect, in any case, we have to establish that this ruling will not be able to be enforced in the Netherlands. And we're not aware of any other court rulings against one of the other accused, other than the rulings that I just referred to. Your Honours, I'd like to conclude. I'm going to end my arguments as I started them. How important this is to the relatives, the importance of fact-finding, justice, and also being able to use their voice, and participation of the relatives in this process is difficult to describe. It's so important for the legitimacy of this process. Also the possibility to submit a claim for compensation against the perpetrator as part of that participation process, and to have something on the horizon in order to be able to enforce those rights. And therefore it's important to restore fairness. Thank you. We will continue after the break for lunch. It's 20 to 1, and we will resume the hearing at 1:30. Thank you.
All rise. Please be seated. Okay, we resume the hearing now. Mrs. Langer, you have the floor. Your honors, let me wait while we hand out all the details. Thank you, Your Honor, members of the court, public prosecution, and relatives and all of those present. The court has asked the Council for the Relatives in its letter of the 14th of July 2020 to assess the number of relatives that want to use the right to address the court and the number that considers to submit a written victim impact statement and a claim for compensation. With regards to the right to address the court also asked to indicate in what manner it could be given substance to. There is no sound upstairs, I understand. Perhaps you can use the microphone better. Yes, I see that it's better now. Thank you. I'm at item 2. For that explanation, I will use the following schedule. The meeting of the Council for the Relatives and the Relatives on the 22nd of August 2020, a response to your questions of the 14th of July, the right to address the court, the written victim impact statement, the written statement, the planning for the right to address the courts, the claims for compensation, and a summary. On 22nd of August 2020, the Council for the Relatives organized a meeting for all relatives at MBC in Nieuwegein. We did not just invite 450 of the clients of the Council for the Relatives, but also the other relatives that are not yet represented by the Council for the Relatives. About 140 relatives attended the meeting, and 120 of those attended in person. 100 persons used the opportunity to attend the meeting by means of the live stream. 40 of those were located abroad and 60 in the Netherlands. And that meeting was simultaneously translated into English for those in the room and those who participated in the live stream. And the participants in the live stream had an opportunity to use a chat function to ask questions, and these were asked live in the room and responded to. The purpose was to provide information to the relatives, but we also knew that your court needed an overview from us. So the purpose was to achieve that overview for you briefly after the meeting. We've informed them about the criminal proceedings, their role, and the rights they can exercise in those criminal proceedings. And it also allowed us, as we said, to ask the relatives to inform us about their preferences, because that's what the court asked for. In order to lay down such an overview and to make it clear to you, the Council for the Relatives has designed a preference inquiry form together with the Public Prosecution Service so that they could state their preferences with regard to those rights. In the past week, many of the relatives have indeed complied with the request, but not all of them have done so yet. And I will explain to you, because new forms are being submitted all the time, so it's a preliminary overview in order for you to create a schedule. So I speak about the updated details, and other than stated in the written notes, more people may use these opportunities. Now, we assist about 450 relatives, which is about 75% of all the relatives, but not each relative is represented, and the Public Prosecution Service also tries to reach people that they haven't heard from. But following that meeting, new relatives report to us too. The right to address the court, item 8. The right to address the court is one of the most important rights that a victim has in criminal proceedings. This is the most adequate manner for them to participate in the criminal proceedings and make their voices heard. And perhaps it's obvious, but the Council for the Relatives requests your court with regard to the requests of those relatives to act with benevolence, and you could think of allowing them to screen a picture of the deceased. And maybe I'm not sticking to my written pleadings, but on that day I talked to clients, relatives, and afterwards too, and you speak to relatives that have lost their daughter, their mother, or their brother, but I also spoke to an older client that had not just lost his son, but the entire family of his son. So they were taken away from his life all of a sudden, and even after 6 years, the impact of the grief is so strong, and it surfaces very quickly, and it's also because no proceedings have been finalized yet. People are very reluctant, they bear their loss in silence, they don't advertise it, and most of them, not all of them, have not been in touch with the media, although that was quite a challenge shortly after the disaster, because sometimes they were really chased by the media. But here, Your Honor, in this court, these relatives can state about their grief, and not just to you, not just towards the outer world, but mainly towards the persons that are responsible for this disaster, whether or not they want to hide. So eventually they will be heard. I finalize this matter by stating that it's possible that we, as Council of the Relatives, we will say something too about legal topics. You may think of providing evidence or the sentence. Now, the numbers. Clerks, I'd already pointed it out to you. The numbers have been updated once again. 76 relatives have indicated that they want to address the court. 66 want to do it in court, and 10 want to do it from another site. Now, how can they exercise their right to address the court? We assume that they can do it in 2 ways. In court, in the courtroom, or by means of a direct video link. Now, exercising the right to address the court in video link is also based in legislation. Article 12 of the Protection of Victims of Criminal Offences decrees, and Article 131 of the Code of Criminal Procedure. Specifically to this MH17 process, the Minister of Security and Justice said that there would be a possibility to speak by means of a video link. And he sent a letter to the House of Representatives on the 7th of January 2019 to allow that. Now, there would be an opportunity for the relatives that live abroad to have a live video link to exercise their right to address the court. Now, that could be difficult. When you're somewhere in Malaysia, it might be difficult to achieve such a live video link. And that would mean that the foreign relatives should have to come to the Netherlands, or that they would exercise this right to address the court by means or at the NBC Congress Center in Nieuwegein. Now, if it's only these 2 options that they have, and Corona still has an impact on the opportunities to fly. That would make it difficult. So this is all conditional right now, of course. I will now start with item 14. There's also an option, of course, to exercise this right to address the court by means of a pre-recorded audio message that will be broadcasted in the room. And then, of course, the relative would also have the choice either to be on camera or not. 10 of the relatives have indicated that they prefer to use that option, but there may be an overlap with the right to address the court, because some of them have indicated that they want to exercise the right to address the court both in the room and by means of a video link. These are only very few, and of course we will communicate the more detailed figures to you and also to our clients. Now, with regard to the reservation we've made, let's say the world would be in lockdown due to Corona, that it would not be possible to travel from Malaysia, Australia or the Philippines to achieve that video link. It will mean that people who want to use a video message, that number will increase, of course. So the video message offers an opportunity to relatives to express themselves as yet without having to travel to the Netherlands. It also has an advantage because, don't forget, some of these relatives really find it difficult to exercise the right to address the court. And although it may sound hard or cynical, some of them may believe that they will not be able to address the court in your courtroom in the next year because of age or illness. The law does not preclude that the right to address the court will be exercised by means of screening of a pre-recorded message. In his letter to the House of Representatives, the Minister stated, besides the option to exercise the right to address the court by means of a live video link, a relative may also request to exercise the right to address the court by means of a recorded video message. Although the law does not specifically provide this opportunity, it does not preclude it either. Now, a similar consideration can be read in the parliamentary documents with regard to the approval of the agreement with Ukraine on international legal cooperation with regard to the downing of flight MH17. It's not new either. The right to address the court by means of a video message has been allowed by judges in criminal courts before, and there's an example. I would like to mention the ruling of the court in Den Bosch, and you can see the details in my written pleadings. So based on the above, the Council for the Relatives requests your court to allow it that relatives can exercise their right to address the court by means of a pre-recorded and submitted video or audio message. And if the court would want to do so, they can of course set conditions with regard to the video or audio message. Perhaps not use music, or perhaps not have moving images in the background, but you would indeed have to think about finding a method that's most similar to the right to address the court in a courtroom. Now, in order to make sure that the video or audio message will also be available for an appeal case, if so, we request the court that these messages, if the relatives wish to do so, would be added to the court file. Now, these relatives will speak in their own language, and when this happens in English or in Dutch, translation wouldn't be necessary. For all other languages, interpretation is necessary. And from the overview, it shows that 55 people want to address the court in Dutch, 20 in English, and one relative has stated that he wants to speak in Dutch. So indeed, an interpreter will be required for translation from German. And with regard to logistics, for the relatives that will speak about such emotional matters, it would not be good to be interrupted by an interpreter all the time. So it seems to be useful to make sure that they can speak uninterrupted, and then a consecutive translation. And in order to be sure that the interpreter can do so, the interpreters will have the written record of the statement beforehand. The court has also asked us whether those that want to exercise the right to address the court would need professional support. And the Council for the Relatives has indeed consulted with the Victim Support Netherlands, and they will be available. Their case managers will be there during the court hearings, and they can offer support. Our lawyers can do so too, but indeed they will make sure that employees of the Victim Support Netherlands are available, and they can also provide support in the preparation of the written victim impact statements and when executing the right to address the court. But you can also imagine that for the relatives, it would be very good to be surrounded by their loved ones, by family members. And before the hearing, we can indeed find out how many will attend, and perhaps we need to take into account that larger families will attend that would like to take seats in the courtroom, and of course that will also depend on the corona measures that apply at the time. Perhaps we may assume that most of the relatives that will exercise the right to speak, that they would indeed like a written record to be added to the case file. Also to make sure that it will be available for an appeal case, if any. Now, this can be achieved because since we will indeed speak their statement, or whether we can submit it to the court. Now, the written victim impact statement. A number of the relatives have already submitted a victim impact statement to the Public Prosecution Service with the request to add that to the file, and our overview showed that 127 relatives want to submit a written victim impact statement. As stated, we adjust the notes. 76 of the relatives have indicated that they want to exercise the right to address the court. Now, how can you plan this specifically? Of course, it's difficult, but let's assume that for each relative, we need 15 to 20 minutes of time to speak. Some will not address the court that long, some may take longer. And of course, we need to take into account that it takes time to take the floor, and of course, the relatives may be overcome by emotions at the time, may have to stop speaking. So, for the schedule, it seems to be safe to assume 25 to 30 minutes for each relative that wants to address the court. Now, it may not just be difficult for the relatives, it will not be just emotional for them, but also for the relatives present in court. And of course, for us, professionals, there are limits to what we can cope with in a day. So, taking that into account, it's just a preliminary schedule. It seems that a maximum of 10 relatives can speak a day. That seems to be most practical. And of course, these are details. At the time, you could try to mix that with the video messages that have been submitted. Now, it would be good for those who have submitted their video message from abroad that they would know when it would be their turn, when their message will be screened. Now, with regard to the damages, it's quite a large number. 316 relatives have informed us that, and I can't stress it often enough, that in principle they want to claim compensation. Of course, this is just a preliminary phase. we've asked the court for an interim decision with regard to applicable law, and that the type of law that applies may block a category of those that are entitled to compensation. Some legal system may not allow brothers and sisters to claim for compensation, for instance. So this is really a preliminary number. And we do not preclude that the number will change. Now, when these claims will be filed, the question is whether the explanation thereof should take place before or after the right to address the court. On behalf of the relatives, we will explain their claims, and that explanation should preferably take place after all of those entitled to address the court have had their time in court. And I will not repeat myself continuously, but due to the wide range of strong emotions, we would like the right to address the court to be finalized. So let's say that on one day it ends and that we could start our explanation the next day, so that it would not be on the very same day. And we've already informed the court that we would prefer the right to address the court to be exercised after the hearing on the merits has taken place. That also applies consequently for the explanation thereof, and we maintain our earlier views on that matter. In summary, the overview boils down to the following. 76 relatives want to exercise the right to address the court. 66 of those want to do it in court, and 10 from a different location. 127 people want to submit a written victim impact statement, and 316 relatives are in principle considering to file compensation for damages. A schedule has been included as an annex, but indeed the numbers have already changed. I will now conclude. The criminal proceedings is extremely important for most of the relatives in order to satisfy their need for justice. It may sound formal, but it really is not a formal matter for the relatives. They see the proceedings as part of justice, and also to take them to the next level of justice, to make sure that they can live peacefully with the results of the proceedings. Martin Luther King said in his Stride Toward Freedom in 1958, true peace is not merely the absence of tension, it's the presence of justice. Thank you, sir. Thank you, Mr. Langstraat. I listened to you with attention, and in the end you said something about the planning, the schedule. As I understood, you said we would prefer for the claims for compensation to only be discussed and dealt with after the right to address the court has been exercised in full. A question that just came up, how would you like to be that practical? Because the right to speak for the relatives is key. Indeed, they will bring their family members or other loved ones in order to have that time in court together. Now, they are present here, or a large number of them. And if the claim would be discussed, I can imagine that they want to be present too, or not. Yes, that's a very relevant question, Your Honor. But I do believe that we would prefer, and perhaps it's difficult to imagine in the setting that we have today, that I gave you an example of a client. The relative should hear a person speak to the court, and then we would not want to switch over to the claim for compensation for that person. That's not what we want. Yes, it feels quite double, but because it also means that the discussion would not be the same for everybody. Not everybody will have submitted a claim in a similar manner, but that also has logistic consequences. Your Honor, I don't believe, because we will explain these claims on behalf of the relatives, and I can't speak for all of them, but I don't think that all relatives will feel the need to be here and to take their loved ones to the hearing. So perhaps that will not happen in practice as much as you expect. Thank you for explaining that, Mr. Langstraat. Well, indeed, what we had planned for today, the explanation of the Council for the Relatives, has now been finalized after the expert opinion has been submitted. Now I'm looking at the defense. Miss, you would not have questions for the experts, but did not want to respond to the Council for the Relatives too. I would like to ask you once again, is that the case? Yes, it didn't change, indeed. Now, I'm looking at the Public Prosecution Service. The question is whether you want to respond to what has been said and the correspondence that you've had. On the one hand, it said we can only respond when we know the position of the defense, but you also wrote that you also want to address the questions that the court has asked and that you also require some time to speak. Yes, we would like to respond to the point of view of the Counsel for the Defense and also answer the question that the court has asked. Is that what you would like to do now? Yes, and how much time would you need?
I think half an hour or less. And there's a point from this morning, request from defence. Would you like to respond to those? And do you know when you could respond? Yes, so that can be done next, I think. Or straight away, if you wish. In whichever order you think is best, President. It'll be a brief response. It won't be going through one question at a time. Okay, so you'll be giving a response now, but there might then be another hearing required for fuller replies. Would you like me to reply now? Okay. Let's hope that my microphone is high enough for me to speak into it. Perhaps that's the most practical way of proceeding. Then we can get it done and dusted. I won't take much of your time. First of all, regarding the general background, Defence raised a number of questions regarding information under Article 149B that is not in the file. And what we would like to say is that we share the defence's conviction this is an exception to the rule, and that we have the prosecution has made minimum use of this provision. There are specific safety issues, sadly, in this case, and we need to respond to those risks. We've frequently availed ourselves of that, but no more than is really required in the light of the genuinely existing risks. The prosecution is also extremely aware that if we receive information leading us to the conclusion that circumstances have changed and that information can be added to the file, although it could not be added earlier, then we will ensure that that is done. We will have it discussed and we will make sure that any such information is put on file. So here we agree with defence on that way of proceeding. In the forthcoming addition to the file, you will see that the names of a number of witnesses are specified, not just their number, and that is with the consent of the witnesses. And this is because we take the view that it is now possible to specify their names. We take this responsibility very seriously, and we will take the same attitude to defence's question of today, and we will look into whether, as defence suggests, circumstances have changed, enabling us to add more information to the file. But in order to proceed with all due circumspection, we need a little more time. And if it is not possible, we will look to see whether additional information can be presented as a response to the defence's question in some other way. We also share the defence's view. We can see in their paperwork that it makes sense, it's logical to invite the investigating judge to express a view on whether circumstances have changed. So we think that both the prosecution should respond to defence's question and the investigating judge should respond to defence in the light also of our response. And that brings me in a nutshell to our following proposal. We suggest that no later than 1 week from today, we give a written response to defence's questions, and we think that we would invite your court to consider today whether it wishes to invite the investigating judge to respond no later than 21st of September to the defence's question and our position, and whether the investigating judge feels it's possible to add more information to the file. I suggest a deadline of the 21st of September. That would mean that you'd have ample time before hearings resume on the 28th of September to work through all the paperwork. You'd then be able to make a decision on the 28th of September, and further information might arise from the written procedure whereby more data can be added to the file. And then if you decide on that on the 28th of September, your decision can be actioned very quickly. That is a proposal from the prosecution. Thank you. So that's your procedural response, is that you would invite the investigating judge to respond, and then we'll hear from defence, and then the court will be able to make a decision, if any. Yes, I think the defence has presented a request, and the prosecution and investigating judge have to respond to that. I don't know whether you want to have another round of talks after that, and whether you want to do that in today's hearing, but our suggestion, I repeat, is that maybe a week before, but you have about a week for prosecution to respond, and a bit longer for the investigating judge to respond. That would give the court time. Defence, do you think that is a practical way of proceeding? Well, it sounds like a good idea, but would you allow us quickly to deliberate on it and respond slightly later after the next presentation? Yes, we will first hear from the prosecution. They'll be responding to what we've heard from the victims' assistance team, and then we will proceed from there on. Go ahead, please. Thank you. On the first day of hearings back in March, we indicated that the prosecution would do everything it could to serve all victims and all relatives, in whatever country they might be. Prior to the trial, the prosecution has done everything it can to keep all relatives fully informed regarding the progress of investigations and their rights in this trial. A great number of relatives are currently receiving team from the Council for the Relatives. We heard from them this morning on the relatives' behalf. The prosecution will now respond to the Council for Relatives' positions without losing sight of the fact that there are some relatives who are not represented by Council. The prosecution is aware of more than 100 relatives who are not represented by Council for the Relatives. Before we come on to address the substantive questions of law that the court raised, we would like to dwell first on the practicalities of the relatives' rights at hearings. So we'll do it exactly the opposite of what the council did. To start off then, the number of relatives. So that the relatives can avail themselves of their rights, the prosecution made a list of all the relatives' wishes in December 2019, and we showed our findings to the court at an earlier stage. Council for the Relatives has given us an up-to-date overview of the number of relatives they represent and the rights which these relatives wish to exercise. There is no current overview of the wishes of those relatives not represented by Council. Some of the relatives in December 2019 indicated that they don't yet know whether they wish to speak at the hearing. Other relatives have not given any response at all. So far, the prosecution has received 11 victim impact statements in writing and 1 video statement. In order to get a complete up-to-date view of the wishes of all relatives, prosecution, in cooperation with the Council for the Relatives, will proceed in mid-September to send a form out to relatives once again, in which relatives will be asked at least to indicate whether they wish to speak, as they are entitled, whether they wish to make a written victim impact statement, and whether they wish to submit a claim for compensation. We can then have follow-up questions in order to ease planning of the hearing, for example, asking what language they wish to speak so that we can arrange for interpretation. And if your court has any questions on this front, we would be very happy to hear them so that we can incorporate such issues into our inventory. In the November hearings, it will be clear which relatives wish to exercise their rights and how they wish to do so. As regards the last point, the prosecution already has a number of practical points to make, but firstly, the right to speak. Experience of criminal cases shows that a victim does not normally wish to speak for more than 15 minutes. The Dutch Victim Support Organisation told us that at an earlier stage, and the meeting with prosecution on 22nd of August and at an earlier meeting with Counsel for the Relatives. Regarding the prosecution, we think that would be a good rule of thumb for the right to speak in this case. To facilitate planning, it would seem to be a good idea to say that any relatives who think they will want to speak for more than 15 minutes should give ample notice of the fact via Counsel for the Relatives or prosecution. If your court decides accordingly, then all relatives could be informed of this by prosecution when we compile our list in mid-September. Plans will have to include any requirements for interpretation and, of course, the time for relatives to enter and leave the courtroom. Prosecution therefore shares the Counsel for the Relatives' view that we should assume roughly 25 to 30 minutes per speaker so that each speaker will have 15 minutes of actual speaking time. Your court also asked how many people would be able to speak on each day. We share the Council's view that a maximum of 10 relatives should speak per day. This is a number which makes it possible, as we see it, to make sure that all parties in the court and all listeners will have adequate attention to pay to any speakers and relatives who wish to speak, and to allow time for additional short breaks. Regarding the right to speak, the prosecution takes the view that it would be possible for some speakers to communicate via a video connection, for example, in Nieuwegein, or a fixed location in a country where a large number of relatives live, such as Australia. That would make the hearing much more accessible to many relatives. This possibility will also be included in our list. Everything, of course, will depend in future, as we've already heard, from whether it is actually possible for foreign relatives to travel to the Netherlands at all. We understand that some relatives are concerned about whether they will be shown on the live stream when they are speaking. This concern must not stand in the way of their right to speak. We therefore recommend that your court could resolve this issue by now already informing all relatives that they can decide for themselves whether they wish their image to be shown on the screen on the live stream or not. This does not in any way detract from the open nature of the hearing, because the speakers can be heard and the court room will be visible, although the speaker will not be. If your court decides accordingly, then our listing exercise in mid-September can also invite the relatives to say whether they wish to be shown on the live stream or not. The Dutch Victim Support Organisation is present at every hearing. including when the relatives are speaking. In addition, the counsel for the relatives and prosecution are always present. For those relatives who will speak via video, it would be possible to provide some other kind of support. When they're connected from Nieuwegein or elsewhere in the Netherlands, the Dutch Victim Support Organisation and Council for Relatives and Prosecution could be physically present. When there's a connection to another country, we would invite the relevant authorities there to provide some other kind of support. Those relatives who speak can then submit a declaration to the court so that it can be added to the file as a written victim impact statement. And regarding such a statement, I'd like to say the following. It is also possible that a relative might wish to make a written victim statement and submit it to prosecution, and then prosecution can add it to the file if requested. At this point, the relative can say whether he wishes the hearing to address his statement, and if so, how. Regarding the nature of a written victim impact statement, the prosecution shares the council's view that it could be made in writing or on video and then presented in the hearing. Finally, injured parties' claims. Relatives have the right to join the criminal prosecution as an injured party. And this happens if they wish to submit a claim for damages. And the claim for damages is dealt with as a civil process between two parties, the relatives and the suspects, as part of the criminal process. This is a civil process which has its own place in this criminal trial, and in due course, your court will provide a single ruling covering any claims. In formal terms, the prosecution is not a party to this process, but it will provide advice to the court on this matter. Prosecution can agree with a written round of claims from injured parties within the time scale presented by the counsel for the relatives. We suggest that firstly, defence should respond in writing. Once the counsel for the relatives, clients, and also the other relatives have finally been dealt with, they can be submitted by no later than the 1st of September, which means that by the 16th of March, defence would be able to respond. That gives approximately a 6-week period. On the basis of the written position of both parties in this process, the prosecution would then be able to adopt its own position within 4 weeks and submit this to the court as a written submission. After this written process, the counsel for the relatives can then make a statement in a hearing, and then prosecution and defence will be able to submit their closing arguments. We agree with counsel for the relatives that there are practical reasons why this right to speak, the treatment of written victim statements, and the consideration of injured parties' claims should essentially be dealt with separately. When relatives make statements, of verbally or in writing, the focus will be on the relative's emotional harm, as we've heard, of course, from the counsel for the relatives. Whereas, while the injured party's claims are being considered, it will be the financial consequences that will be discussed. And here in particular, there'll probably be more debates of a legal nature. The prosecution therefore thinks it is appropriate to consider these two issues separately in the hearing. That will make things more efficient. The prosecution therefore takes the view that any speakers who wish, perhaps because they live abroad or suffer from poor health, should be able to exercise their rights in a single time. This must surely be possible if they express their wish in due time. Here again, it applies. If your court decides accordingly, then our listing exercise in mid-September can include information that the right to speak and the injured party's claim will generally be dealt with separately, but in cases where this would be excessively burdensome to particular relatives, exceptions can be made for them. After the claims have been submitted, The prosecution will seek to make sure that the absentee defendants Gierkin, Dubensky and Karchenko are informed of them. We are not obliged to do so, but we wish to give the absentee defendants the maximum possible opportunity to respond to such claims. The prosecution will include this information in the summons to the fresh hearings which are planned for the 15th of April next year and following. The summons will have to be sent out in September, and experience has shown that implementing letters of request of this kind always takes time. For that reason, the prosecution suggests that claims should be submitted no later than the 1st of September. This means that the absentee defendants would be informed as efficiently as possible. There's a clear basis for further planning, for consideration of the claims, and there is adequate time for a full debate with defendant Pulatov. It goes without saying that relatives also have the right to submit a claim after the deadline of 1st of February. However, late submission may raise admissibility issues. Now, the substantive questions of law that the court presented to Council for the Relatives on the 23rd of March. And the questions also submitted to the prosecution. One is the jurisdiction the court has in considering injured parties' claims. Two is the possibility of a separate rule on the claims in absentia, and third, the civil law of application to the claims. Now, we have already given preliminary answers to the first two questions. That was on the 27th of May. They are in line with the conclusions of the Council for the Relatives and the experts they consulted. Defence has expressed that it does not wish to express disagreement with these views today, and our position also remains unchanged. In a nutshell, we would say that the court's jurisdiction regarding the injured parties' claims arises from the jurisdiction in the criminal case, and that no separate decision for no separate in absentia decision is required. In addition, we agree with the Council for the Relatives and their experts that it is Ukrainian law that applies to these claims. There are other recent cases in the Netherlands, which you've heard about today indeed, regarding crimes of violence outside the Netherlands, where foreign law was applied to the injured parties' claims. Here again, we would refer you to Dutch court rulings regarding Rwandan law and Ethiopian law being applied to the injured parties' claims. In those cases, the injured parties' lawyers themselves provided the foreign legislation either by the International Jurisdictional Institute or lawyers from the relevant country, and there again we think this is the appropriate way to proceed. We therefore do not agree on this either with Council for the Relatives. Thank you. Well, I think that we've heard from everyone. We will now interrupt the hearing until 3 p.m. so the defence will have an opportunity to respond briefly. I don't know whether perhaps the Council for the Relatives might also wish to respond to what prosecution has said. Very briefly, President. Yes, we'll give you the opportunity in due course. And then we will decide when we adjourn till. It's important here to note that 28th of September is when the next block of hearings will begin. You want to see them whether defence will be present. Okay, that's just a question to be addressed. Okay, I hereby adjourn until 3 o'clock.
All rise. Please be seated. Yes, well, we returned somewhat later than we'd planned. In the meantime, we deliberated on the question raised to the court, whether we could take an interim decision. Well, we're not ready yet. And so for now, we decided to return and to listen to what you would like to put forward and also what the Council for the Relatives would like to put forward. And then we will interrupt the hearing again, I think until 4:30, and then we'll be able to share the decisions that we've taken. And the advantage is that that'll be the wrap up for the day. Mr. Ndusgater, Defense Counsel. Very briefly, the request for the adhesion of the 149B documents, as far as that is concerned, paragraph 15 and 31 of our pleading notes, we summarized the request that we made in this context, and they've been printed in bold. The proposal made by the prosecution service now would fit that in the sense that should the court decide to ask the investigating magistrate for advice, if the prosecution service is consulted, that the defense would also like to respond to that and take a position in that matter. So in our request, the way we've drafted it, it says, after getting the advice of the investigating magistrate, and if you do get the advice of the investigating magistrate, and if it is decided that the prosecution is allowed to take the floor and to respond to that, then we would also like to respond and take a position. As far as we're concerned, we can do this in the short term. And the second point was whether we intend to attend the hearing on the 28th, and I can confirm that. Yes, we intend to attend the hearing that starts on the 28th. Presiding Judge, did I understand you correctly that you're saying that if the court involves the investigating magistrate, and if the investigating magistrate reports on the matter, reports to the prosecution service, that you also want to respond? Yes, says the defense counsel. Well, we would like to be involved and to be notified, and if the examining judge reports on his or her findings, then I suppose that he or she will know that we would also like to be informed. The presiding judge. I'm looking at the counsel for the relatives. Yes, Your Honor, just some practical issues that I think that we need to agree on with the prosecution. I don't think that we have to do this through the court, so we will discuss these matters bilaterally with the prosecution service. Presiding Judge, thank you. Fine. So as I said, we will adjourn the hearing until 4:30, and the court will then disclose its decisions for today.
All rise. Please be seated. Okay, the court has deliberated about the requests and the applications of today, and it leads to the following notification. First of all, with regard to the request by the defense team, the suggestion to submit requests for investigation in writing, the court can agree to that requests for investigation are submitted in advance and that the Public Prosecution Service will respond to these. However, it is in the interest of public interest to discuss these requests at a public hearing, and that the court will only take a decision in court after discussion by the parties. Indeed, the response time will be shortened by this procedure. Secondly, the requests for mutual legal assistance that have been sent. It was not clear to the court that it is essential, after the statement of the defense, that the investigating judge must provide the phrasing of these requests to the defense. The third item, 149b section, the court will follow the following procedure and the case is referred to the investigating judge for that matter. The Public Prosecution Service will ultimately reply by the 7th of September to the responses of the defense team. The investigating judge is requested to express itself about the requests of the defense by ultimately the 21st September, under observation of the remarks by the public prosecution. Then the court will, in the hearing block of the 28th of September, take decisions if so required. And the court furthermore requests the Public Prosecution Service and the investigating judge to also include in the above what was stated by the defense team with regard to the witness X48. And to make it clear, these are the headings 35 and 36. Now, I arrive at the explanation today and what was argued by the counsel for the relatives. First of all, the claims, the requests, and the right to address the court. The court agrees on key items to the modalities as stated by the counsel for the relatives and the Public Prosecution Service, the drafting of written victim impact statements, and submitting claims of the relatives. That means that the court departs from speaking time of 15 minutes. If longer time if more time is required, the speakers will have to inform the court beforehand. It means that 10 speakers can speak each day. The right to address the court can be executed in the courtroom or from another location by means of a live video link or by means of a pre-recorded video message. It is also clear to submit a written victim impact statement. Requests of the relatives that want to address the court will be taken into account. In as far as necessary, these features can be included in the overview that the Public Prosecution Service and the Counsel for the Relatives will prepare. More practical agreements must be aligned between the court, the Counsel for the Relatives and the Public Prosecution Service. The court would like to point out the following, however. Although the law does not limit the right to address the court and submitting written statements, it is required for a proper organization of exercising the right to address the court and the and dealing with the claims as well as progress of the case itself, it is of interest that the relatives make their preferences clear at an early stage. They can do so by contacting counsel or to report to the Public Prosecution Service. And for many of the relatives, it applies that they've already done so. However, this hearing and what is said here is also heard by those that have not done so yet, and we particularly mean to address this message to them. With regard to the time to submit claims for compensation, the court will determine that these have to be submitted by ultimately the 1st of February 2021. The court assumes that these claims will indeed be drafted in the standard manner of the form for compensation for damages. It means that any compensation that has already been received or payments that have been received from other parties will be included. After submitting these claims, there will be written rounds and the court will determine the timing later. It also relates to the progress of these criminal proceedings. In exercising the rights of the relatives, first of all, those entitled to speech will be allowed to do so, and then the claims for damages will be dealt with. With regard to preferences for a combined treatment of the right to address the court and the claim submitted, we will take that into account. With regard to the legal queries, the jurisdiction of the court and applicable law. Now that no claims have been submitted yet, is what the court will consider later should not be regarded as a decision but as a line of thought merely. Jurisdiction of the court, together with the counsel for the relatives and the Public Prosecution Service, the court takes the point of departure that its jurisdiction on civil law ensues from the criminal law jurisdiction. The link between the civil law jurisdiction and criminal law jurisdiction does not seem irresponsible based on international law. Also based on the Brussels I resolution and the Treaty of Gano. This resolution and this treaty do not apply in itself in this criminal case, but they do indeed present the wide link between the civil law authority to jurisdiction to the criminal law jurisdiction. Now, with regard to the applicability or the applicable law, the court believes for now that the point of departure should be that Ukrainian material right on substance applies, but also asks attention for the following. To what extent can substantial Ukrainian law be limited by a Dutch criminal procedural law stipulation, for instance, Article 51F of the Code of Criminal Procedure? In case law, the applicability on criminal law did not lead to compensation of affectional damage after applicability. And the question is, would it have been possible under foreign law? Now, for now, these are the decisions that the court can give you today. The text will be included in the official records of the hearing of today. And I would like to remark that the text that I've read to you has been edited, but it may be in more detail in the official record. But the purport will be what I've just told you. For now, this is the end of this day, and I've already told you that the case is referred to the investigating judge with regard to the requests of the defense with regard to 149B. For now, we interrupt this case up to Monday, the 28th of September at 10 o'clock, and then we will continue this hearing. So for now, we are finished, and I thank you once again for your attention and your patience today.
nou doen? Mijn bril op of mijn bril af? Ja, maar ik vind het toch ongemakkelijk.
Welkom bij het resume.
Welcome to this summary of the day in court concerning the MH17 criminal case in The Hague. Now, Ms. Knijf is going to give you a summary of what took place in court today. After that overview, you will have an opportunity to put questions to her. But first, I give the floor to Ms. Knijf. Good afternoon. The third block of hearings in the criminal case opened today. And as is customary at the start of each hearing block, the presiding judge gave a brief overview of what had been covered in the previous hearing block, of the developments since the last hearing, and of what he intended to cover during the hearing today. Now, first of all, regarding developments since the last hearing. In its decision of the 3rd of July, the court granted a number of applications and requests made by the prosecution and the defence, including requests that a number of witnesses be interviewed. The investigating judge has initiated the relevant investigative work. If you would like to know more about the role of the investigating judge in criminal cases, I suggest that you view the video available on our website. That is to say, www.courtmh17.com. I turn now to requests made by the defence that documents be added to the case file. So today the defence made a number of requests that documents be added to the case file. The documents concerned are requests for legal assistance issued by the investigating judge and documents or parts of documents that are currently in the investigating judge's hands. Today, the court ruled that the defence had not provided sufficient arguments for it to order the investigating judge to make the requests for legal assistance available to the defence. The court followed the prosecutor's suggestion and ruled that the prosecution give its response to the requests made by the defence, that documents be provided to it by the 7th of September. And the court asked the investigating judge to give his views on the requests by the 21st of September at the latest. The court stated that it would announce its own decision on the matter during the hearing block, which opens on the 28th of September. As regards the counsel for the defence, counsel for relatives and jurisdiction and applicable law as regards claims for damages. In its decision of the 23rd of March, the court put a number of questions to counsel for relatives concerning the intentions of the relatives and the possible filing of claims for damages by relatives. These questions related, for example, to whether the court has jurisdiction to hear the claims for damages and what body of law should apply when adjudicating the claims. So those questions were on the agenda for today's hearing. Before answering those questions in court, counsel for the relatives underlined how important it was that the relatives not be seen as a single group, but rather be seen as individuals, each of whom had suffered a terrible loss. Each relative had his or her own story, his or her own desires, wishes, and hopes. Counsel pointed out that for the relatives, the purpose of the trial is to obtain some form of redress, and damages is one means of recognition of their loss. Counsel for the relatives commissioned an expert report, so expert advice, to assist them in answering the court's questions regarding whether the court had jurisdiction to hear the claims for damages that may be filed by relatives and regarding the applicable law. In court today, counsel for the relatives explained the tenor of that advice. In a nutshell, the experts had concluded that the court's jurisdiction to adjudicate such claims arises from its jurisdiction to hear the criminal cases against the accused. In addition, it was the experts' view that in adjudicating the matter, Ukrainian law should be applied, because the occupants of flight MH17 died in its territory. The court is currently minded, or currently shares the view that its jurisdiction to hear the claims for damages flows from its jurisdiction to hear the court cases. Also, the court is currently of the view that Ukrainian law should be applied because the occupants of flight MH17 died in the territory of that country. These are preliminary views of the court. Turning now to the matter of the relatives' right to address the court and the filing and discussing of claims for damages. Currently, 76 relatives have stated that they wish to exercise the right to address the court, either in person in the courtroom or from another location, for example, via a live video connection from overseas, or by providing a pre-recorded video in which they give their views. Counsel for the relatives and for the prosecution gave their views on how and when this right to be heard should take place and how much time was needed. The court agreed with what they heard that a maximum of 10 relatives would be able to take the floor on any one day. As regards the claims for damages, the court decided that they must be submitted at the latest by the 1st of February 2021 to the court. The court also reported on their plans to visit their client. Counsel representing one of the accused announced that they have been able to book a flight and will shortly travel to the Russian Federation to confer with their client. So, what's next and when? Well, the court proceedings will resume on the 28th of September 2020. At that point in time, the matters concerning the defense will be discussed. I turn now to the hearing dates currently scheduled. On the 3rd of July, the court scheduled the hearing dates for 2021. However, some changes have been made to that schedule since. The latest schedule can be found on our website, but please do note that the exact days on which hearings will be held always depends on how the proceedings unfold, so we would suggest that you keep an eye on our website. Thank you. Thank you, Ms. Knijven. Are there any questions from the floor? Apparently there are no questions from the floor, which means that I shall close this session. The court will sit again at 10 a.m. on the 28th of September.